I'm aware from the opening session and from my conversation with Daniela last evening that the breadth of this conference is extremely wide. It covers a great many topics and subjects. I will touch on only two, and they, in some senses, are fairly narrow, but they are, I hope you'll agree, extremely important. Naturally, being a judge of the Supreme Court of the United Kingdom, my presentation will be largely dictated by the judicial perspective. The first, as Fernando has said, the use that we make of technology. He was kind enough to say that I was going to talk about how we use technology in court. For my sins, I am the justice who is in charge of information technology in the Supreme Court in London. All of my colleagues are almost as old, and in some cases, believe it or not, even older than I am. And we have all, of course, grown up not accustomed to the use of technology. Being a judge in the United Kingdom involves having been a lawyer for many years before you're appointed to judicial office. And normally, in order to be appointed a judge of the Supreme Court, you will have had to occupy a position in lower courts for many years before appointment to what is the final court of appeal in our jurisdiction. Throughout virtually all of our experiences as lawyers and as judges in lower courts, we have never had recourse to technology. And therefore, although I will talk about how I use technology in our Supreme Court, I would like to be able to say that this is universal among my colleagues, but I would be less than honest if I were to make that claim. The truth is that some of my colleagues find the use of technology forbidding. They are apprehensive about learning a new skills set at their very advanced age. And part of my campaign has been to persuade them that if they embrace technology, they will find that their way of working is utterly transformed and made infinitely easier. In that campaign, I'm afraid I must confess, I have so far been spectacularly unsuccessful. Perhaps I ought to send them to Rome in order to attend a conference such as this, so that the benefits of technology may become more apparent than I have been able to expose them so far. In the Supreme Court in London, we have a wonderful communications team led by a very able communications officer. And when they learned that I was going to come and talk to you about the use of technology in London, they were in their turn quite apprehensive because of my known propensity not to remain on message. So they required me to submit to a film of what I should say, or the filming of what I should say to you. And I'm afraid you now must also submit to this. And Julio is going to play the film, and then I'll have a few more words to say. Well, welcome to the Supreme Court of the United Kingdom. We are here in Court 1, which is the largest of our courtrooms. And as you can see, there's a reasonable amount of room for the storage of papers. But for reasons of cost, efficiency, and not least the environment, we are very keen to encourage parties, and indeed the justices of the Supreme Court, to become less dependent on bringing large volumes of papers with them to court. And in order to facilitate this, our practice directions stipulate that every party to a case has to lodge what's called a memory stick. This contains the core bundle and all the relevant decided cases and statutory material on which they intend to rely. This is formatted as a PDF document. Each page is numbered to allow for ease of navigation during the oral hearing, and we insist that parties cite both the bundle page number and the hard copy page number if that is different. On a sitting day, most of my colleagues would arrange for their laptops to be set up in court, ready for them to use in the course of the hearing. And all we have to do then is to ensure that we've copied the PDF onto our laptop before the hearing begins. Now, I have mine here to demonstrate to you how we use the basic Adobe software in order to navigate bundles and to annotate them. Firstly, quickly navigate to a page simply by entering the number given to us by counsel. And if you can see that there's a small panel at the top of the screen, if counsel refer us to, let us say, page 340, we simply enter 340 into that little panel, hit enter, and it brings us to the page that counsel wishes to refer us to. Secondly, we can make comments on any particular section or highlight it with a specific color. My practice is to use a different color for the different counsel. So on the right of the screen, you will see here various annotations that I have made. And if I click on one of those annotations, it will bring me directly to the page that I have highlighted. Red in this instance is the color that I've chosen for the respondent, but I choose other colors for other parties. For instance, this color for the appellant. And again, if I want to return to the page that I've already highlighted, I simply click on that page and it takes me back to the point in the PDF that I've already highlighted. We have also equipped our courtrooms to enable virtually paperless hearings to take place. Flat screens have been installed beside each justice's chair on the bench, operated by a central computer which is situated on the solicitor's bench. This enables counsel to direct attention towards a particular page and for the parties operator to rapidly navigate to that page without the need for the justices to do so. And this facility is, of course, particularly helpful in appeals that involve very many papers. Many of those papers are not necessarily going to be referred to during the oral presentation of the case. Now, we cannot make notes on the networked flat screens, but we can, of course, do so on our personal laptops, which, as I've said already, many of us take into court. Before we leave the courtroom, I should also point out that the very cameras that you can see me through now are used every day when the court is sitting. These cameras create video footage which, along with the core volumes, form the official record of the proceedings. And that means that we don't have to have stenographers or transcribers in the courtroom during our hearings. We also live stream all our hearings online via our website, and we make footage available to broadcasters and educators on request. More than 15,000 people each month tune in to watch our proceedings. And now you have joined them. It's a slightly unsettling business watching yourself on screen. So you'll forgive me if I'm more than usually incoherent after that less than pleasant experience for me, and I'm sure not a delight for you. It is a frequent objection that to install the type of equipment that we have introduced into the Supreme Court in London is very expensive. And we have been fortunate in that our court was established in 2009, firstly before the worst of the economic recession occurred, and secondly, when the opportunity to introduce new technology existed. So there was a happy coincidence between those two circumstances. But to the objection that it is extremely expensive to install this type of equipment, my inevitable rejoinder is that money will be saved within a very short time of its installation. And to give you a concrete example of that, we in the United Kingdom Supreme Court normally sit in panels of 5, as well as the justices, the judicial assistants, the law reporters, and 1 or 2 of the administrative staff required to have copies of the documents that are submitted. We will normally sit for 1 or 2 days, and in order to produce the 12 hard copies of a typical case, the cost is in the neighborhood of €50,000. If we conducted our cases electronically, the cost to the parties would be €1,000. And when you translate that over a period of a year, where we hear 100 cases in the Privy Council and perhaps 40 cases, in the Supreme Court and 40 cases in the Privy Council, one can immediately see the enormous saving in costs that can be achieved. Now, there are 1 or 2 other technical details that my communication staff have told me must be conveyed to you, so you'll forgive me if I read them out. First of all, we have our own in-house IT network and systems, and that has been extremely important in terms of cost savings. Originally, we were part of the Ministry of Justice, and although one would have expected that since they operate on economies of scale, that the cost to us would have been much less. In fact, we found it was much greater. Now, I'm not saying that that experience can be translated throughout the European Union, but it is an interesting observation to make. We use standard software, Office 365, Word, and so on. We have achieved considerable savings by having an off-the-shelf software package, in this case MS Dynamics, and that operates as a case management system, and it has led to, I'm told, enormous cost savings and greater control. Wi-Fi provision has been upgraded and extended to cover all courtrooms. Parties can have access to fiber optic broadband in the court in order to facilitate the use of their own IT if they wish to do so. The system is supported by the use of cloud storage and the use of direct access, and that makes remote working for justices and staff much easier and more efficient. A lot of us work at the weekends, and it's very important that we have more or less instant access to the intranet that the Supreme Court operates. I am told to say to you that this has been supported by the provision of smartphones linked to the UK Supreme Court IT system. I'm not so sure that smart is the adjective that I would use to describe these phones, but perhaps it's the user of the phone who isn't very smart, because I find it somewhat difficult. And as I've told you already, all cases are filmed, and the digital record, along with the core volume, is what forms the official record in every case. Appearance in any Supreme Court can be a daunting experience, even for the most seasoned of advocates. And I'm told that those who find that they're going to appear for the first time spend many long, and I'm sure extremely sad hours watching cases in order to get the flavor of the particular justice before whom they will appear. That is something that I view with less than complete happiness. So far as dissemination of the work that we do is concerned, as soon as a judgment is delivered, it's posted on our website immediately. And that's accompanied by a 2-page press summary. We find that there is a large uptake by journalists of the press summary. And while, of course, we're not in the business of manipulating the presentation of our judgments, it does avoid considerable misunderstandings, and we are told by the media is a very useful commodity. As well as that, a filmed summary of a justice summarizing the judgment, because unlike the position in the House of Lords, we give a short summary of the judgment when, at the time that it is delivered, that is summarized and posted on the Supreme Court's YouTube channel. I was taking my grandsons to a park in Northern Ireland Christmas last year, and I was approached by a young woman, and she said, "I know who you are." And that's always slightly disturbing, especially in the presence of one's grandchildren. And I said, "Why?" She said, "Because I watched you summarizing a decision in a case called Lundy." And I said, "Where did you watch it?" She said, "I watched it on YouTube in New Zealand." In any event, our planned future developments are that there is a pilot underway to allow parties to create and submit electronic bundles online, and that will replace the need to provide multiple USB sticks. And the system will also allow justices to more easily view, annotate, and search and access the search bundle. If the pilot is successful, we plan that in the future, parties will be able to download and complete various forms which must precede any presentation of an appeal in the Supreme Court. And that will be possible to be done all online. As well as being the Supreme Court for the United Kingdom, we act as the Judicial Committee of the Privy Council, which hears appeals from former colonies of Britain. They are, in many cases, very far-flung, a lot in the Caribbean, some in Mauritius, the Cayman Islands, the Channel Islands. And we find that the use of technology is enormously beneficial to those who are presenting appeals from those jurisdictions. And in due course, we hope that many of the cases that we hear from places such as Jamaica or Barbados will be conducted entirely online. Now, I have a colleague who, every time he hears that I'm going to make a speech at a conference, reminds me, he says, "Never forget that there is no such thing as too short a speech." But I always do forget, and I've already gone on for far too long. May I say this by way of conclusion? It seems to me that technology is an undeniable and permanent feature of the lives of our children and grandchildren. And it seems to me also undeniable that they will expect that when their lives come in contact with the legal systems of our countries, that all which technology has to offer must be available to them. For that reason, if for no other, it's the responsibility of our generations to ensure that we are all ready to meet the needs of our societies in the future. Thank you for listening.
Well, Dr. many thanks for this very concrete presentation. And it's a real illustration of using e-justice, and in this case, in the Supreme Court of the UK, hearings, records, distribution of judgments. E-justice is really in the highest Supreme Court in the UK. Many thanks for this. Now we are going to have a presentation by Judge Jean-Paul Jean. He is the director of the research, documentation and report department of the Supreme Court of France. He is president of the chamber, and he is the director of the all documentation services at the Supreme Court in France. Monsieur Jean, vous avez la parole.
Thank you, Mr. President. Ladies and gentlemen, dear colleagues, thank you for your invitation. Yes. Okay. And thank you very much to Italian authorities for this invitation and the quality of organization. I'm French, so I speak in English. You know, you know how French people speak English. So, but it's a great pleasure to be again in Roma. So after the video conference of Lord Bryan, I'm sorry, I'm not Stephen Frears, and I don't show to you a movie, but just some pictures. I will try to be modest, Cartier-Bresson. So firstly, I would like to use my second cap because some of you know that I'm the president of the working group of CEPEJ from the Council of Europe. And last week I presented the report of the CEPEJ. You have just here the summary. The report is 500 pages, so you have just here the summary. And I think that the first thing is to show before the level of computerization in each country. And here you have the ranking of Council of Europe about e-justice in Europe. And you can show that we calculate a global rank of ET with three types of use: computer facility for the direct use of judges and court clerks, the system for the registration and management of cases, and electronic communication between the court and other practitioners. Yes. And you can see that the country, we have the best rank are UK, Italy, the Nordics country, and the Baltics, and Slovenia and Austria. Yes. Just after, because the limit is 60, yes, we have France and Spain, yes, for a colleague, yes, but we are close, It's like in football, yes, in soccer, no problem. And we have other ranking about use of video conferencing, for example, and so on, okay. For France, I just want to explain the increase, this increase of electronic communication And this increase is to be in a set. You see for civil cases in 2007 between the court and lawyers, payment orders, the dematerialization is 2012, yes. December 2013, for the first time, electronic signature of decision by the Prime President of Court of Cassation. I think it's the first in Europe, but I'm not sure. He said, I think it's exact, yes. Your Prosecutor General for Italy, for Court of Cassation spoke this morning about criminal cases, and we have now electronic relation between police and gendarmerie with public prosecution. And this year, we try to have, for creation of business, for register, quotation data in electronic format. Yes, it's a priority of European Commission. Yeah. Just this electronic signature in December 2013. And just to evaluate the activity of the French Court of Cassation, just to see that we have close to 1,300 cases each year at the French Court of Cassation. And you see criminal cases, 8,000, and civil and other cases, 22,000 nearly. So we need to use electronic files, yes. I just want to explain that we have overcome technical steps and legal steps. The first step for everybody, for each country, is a technical step with email, online consultation of database, and so on. I don't insist. But the second step is the use of electronic communication technology and to have a real legal framework. So we have two aspects as a mean of evidence and for electronic pleadings. In 2000, some dates, the civil code about evidence, the principle, you can read this article, the writing in electronic form is the same as a paper-based writing, but you are just to verify security and integrity. In 2004, the definition of what is an electronic communication, emission, transmission, reception of scene, and so on. Yeah. In 2009, it was very difficult in France, and principally at the level of Court of Appeal, because the decree has been decided in 2005, but it entered in force in 2009. Yes. Mailing, delivery, and notice of pleadings may be done, yes. And the condition is the prior agreement of the recipient of the document. I think it's the same for in other countries. It's why I explain it, yes, because it's interesting to see if we have the same principles, yes. And the decisive step is at the level of Court of Appeal. Because we have an important reform at the level of Court of Appeal. Because we have a reform at the level of Court of Appeal. Yes. Because we have had specialized lawyers up to 2011, but with Supreme, we delayed this French avoué, special lawyers. So the reform is entered in force just at the 1st of January of 2013, yes. And we have to send now the pleadings by electronic communication to the Court of Appeal. This evolution is the same for bailiffs and lawyers. I just gave an example for bailiff. During the same time, a decree of March 2012 can regulate the electronic deeds of bailiffs, but the Parliament asked the National Chamber to hold a register of people having consented to the electronic writ. And you have this picture, this website, where any person, individual or professional, can fill a consent form, yes. And so the writ are electronically sent to her, to this person. Yeah. But for judges and lawyers, we have two different networks and a relation between these two different networks. For judges, the network of Ministry of Justice, it's a French specialty. For judges is the network of Minister of Justice. My Prime President and I prefer to have a network only for judges and not for minister, but today it's the reality, an intranet. And for lawyers, they have a private virtual network of attorney. And what is very important today, 75% of lawyers, we have in France 60,000 lawyers, 75% are registered to this network, private network. So today, individuals can receive a notice of pleadings electronically, but are excluded from electronic communication, okay, and cannot access to this private network. And today, papers governs the communication in all proceedings with compulsory representation. And just for social dismissal cases and so on, we have not compulsory representation. So in consequence, no electronic communication, but it's compulsory for all other civil cases. And the Court of Cassation say, it's a very important opinion, in September 2013, the registration of an attorney for the private virtual network implies consent to receive notices of pleading electronically. At the level of the Court of Cassation, we have specialized lawyers. So, in 2008, this order reserves the use of this electronic procedure for this lawyer to the Conseil d'État and Court of Cassation. And they enter in a certification process that guaranteed security and confidentiality. So, all appeal, any appeal, is therefore dematerialized in civil matters. All the appeal. This registration of the appeal is transmitted to the registry of the court, and the signature registration are made thanks to a secure device, and my service controls this device. And we have a file is created in the court's computer server, and the lawyer has 4 months to conclude. Yes. And my office has a central role in this dematerialization process. And we use a specific application software. And we search interrelation between cases in order to group them, either when they raise identical legal issue or when they are linked. And now we use systematically new technology because we have had a special project with fundings, with conception and implementation. And it's why we are very different of other French courts, yes. French Court of Cassation is in advance compared to the other Court of Appeal, for example. Some picture about this dematerialization at the French Court of Cassation. All the procedures are now dematerialized. The only exception are criminal cases, because lawyers is not mandatory, compulsory, sorry. As in, I think for Italian Court of Cassation, we have six chambers, yes. 1 criminal division, very specific, 3 civil, 1 financial, 1 social division. It's the same, yes, I think. So just some pictures, the 3rd, 2nd division, 3rd civil division. So you can see how judges use computers for deliberation, yes. Financial and economic division, social division, and criminal division. And now, how does works the judge with the reporting counselor? It's the same that in England, I think in the UK. He uses a virtual office, accessible either from the court or from home. And some judges don't work in the Court of Cassation, but at home, yes. You know the south of France, yes? Yes. Yes. So, he has access to all documentary resources. And he can examine all case history, and constitutional lawyers, filling of briefs, hearing, and so on, and is able to check the compliance with procedural time frame, for example. Yes. What is the work of this judge? He can download any document, brief, a statement of defense, appel decision, and so on. For this work, he has access to online database, law, private legal publisher, and so on. And now, for example, the ruling. You have the ruling, I think, of the criminal chamber, How do the judges work? The president is here. 1 computer is available for each judge, and judge can see and follow the draft decision, because it's very important. Each word is important. You know how judges are very obsessional, I think, about the word. It's important. And any individual president can see electronically his decision. Just after the decision, he can see electronically, and the decision can be sent to the lawyer. Yeah. This dematerialization process also applies to the dissemination of the jurisprudence, to the trial judges with internet website, and to the public with the public website. Just and some picture to before my conclusion. You see here the internet website accessible to any judge with bases to documentation, research, reporting department. We have an internal JuryNet database with all decisions of Court of Cassation since 1990 and the important decision before. Up to, we come back to 1960, yes. And we have also the report of the judge, because you know that French decisions are very hard to read and to understand, but we have the important report of the judge and the Advocate General opinion. And we have hyperlinks with jurisprudence, with professionals, with academics, and so on, yes. And just to see the internet website with of Court of Appeals. And just to finish, other documentary resources, for example, the K constitutional questions, a section methodology with, for example, of draft decision for trial judge. You have a fact sheet, you have templates, methodological manuals, and so on. We have a section documentation with thematic studies for judges. And now just the public website, just to show it, with a newsletter of the court, annual report, and selection of decision. For example, I participate in September to a very important decision concerning the opinion of the court on the adoption by the wife of another woman who gave birth by medically assisted procreation carried in Spain. Yes. And you have this decision applied. We have also a Twitter account, yes, with, you can see 20,000 followers, because many attorneys, you have YouTube, we have, and we have Twitter, because many attorneys among them, because we have a direct link to the commented decision or events. So with limited signs, we have the link to the decision and commentaries. It's very important. And we can see all the decision on a public website whose name is Légifrance. It's a public website. And the last picture to show tradition and modernity. It's the same that I think in England, in UK and Italy, you see the commercial, the business court with effectively with the chamber and the computer. Thank you, and excuse me for my bad English. Yes.
Well, really, Judge Jean, many thanks for your presentation. We had the interesting possibility to see how the Supreme Court works, and we noted with particular interest that you are in advance to the Court of Appeals. So you are giving the example to the other courts in France. It was also interesting to see the legal framework and the implications as a consequence of e-justice. So with this, we can go to the third and last intervention on this topic, e-justice and e-law in Supreme Courts across Europe. And we have the pleasure to have Judge Enzo Vincenti, giudice alla Corte di Cassazione Civili e membro del CED, Centro Elettronico di Documentazione. Prego.
Grazie Presidente. Prima di tutto un doveroso ma ovviamente sentitissimo ringraziamento agli organizzatori della conferenza per avermi officiato e onorato di una tanto importante partecipazione attiva nell'ambito di questa conferenza e di questo panel di così alto profilo scientifico istituzionale. E visto che questa sede, che è la sede della Cassazione italiana, è anche la mia casa, un ringraziamento particolare a voi tutti presenti in quest'Aula. Ancora grazie dunque, e vengo al tema che riguarda una specificità dell'esperienza italiana a cui ha già fatto cenno peraltro il Procuratore Generale, che è quella della banca dati informatizzata di giurisprudenza, legislazione e dottrina creata e gestita dal CED, cioè il Centro Elettronico di Documentazione della Corte di Cassazione Italiana, e su cui pertanto è incentrata questa breve relazione. Mi premeva una breve premessa prima dei dati e dei contenuti propri che possono interessare quanto appunto alla banca dati. La premessa è quella di mettere in rilievo che la storia di Italgiure Web, è così appunto è denominata attualmente la banca dati, che è nata nei primi anni 70 con il nome di Italgiure Find e si è poi trasformata negli anni 90 come Easy Find, prima di diventare appunto dal 2003 Italgiure Web. Mi preme appunto di porre in rilievo che la storia di Italgiure Web non è soltanto la storia di un progresso meramente tecnologico, che pure c'è stato e che ha dato risultati di grande rilievo, ma è la storia piuttosto di un'idea che, come detto, ha mosso i primi passi negli anni 70, nel 1970 circa, ma che già all'epoca era tale da far intuire quali fossero le grandi potenzialità e gli obiettivi ambiziosi che forse soltanto oggi riusciamo a leggere chiaramente. Forse allora non si trattava unicamente di coniugare, di mettere insieme l'informatica, e cioè la risorsa strutturale della società post-industriale, al diritto, così da poterne facilitare i modi della conoscenza e della fruizione, come del resto accadeva allora in quasi tutti i campi del sapere e dell'agire umano, quindi secondo una cifra che non era esclusiva del sapere giuridico. Nel contesto di questo obiettivo, che pur c'era, l'idea era piuttosto quella di orientare l'informatica ad un progetto che avesse come di mira di riportare all'interno dello stesso sistema giudiziario il dato giuridico, spezzando in questo modo quella rigidità dell'accesso al dato giuridico che essenzialmente registrava la presenza di fonti allocate all'esterno del sistema giudiziario, penso alle riviste giuridiche e ai repertori giuridici. Questo non per sostituirsi a queste fonti esterne, la cui vitalità e validità non era assolutamente messa in discussione, ma per affiancare ad esse un ulteriore strumento che, in quanto pensato all'interno della giurisdizione e gestito all'interno della giurisdizione, fungesse proprio da volano neutrale per la più estesa e rapida fruizione del dato giuridico e quindi per il migliore esercizio della giurisdizione stessa, ha avuto riguardo ai caratteri propri che sono quelli di autonomia e indipendenza impressi dalla Costituzione italiana, ma secondo un patrimonio comune alla cultura giuridica europea. Ed è forse particolarmente significativo che un progetto siffatto e la creazione quindi della banca dati venne realizzata proprio dalla Corte di Cassazione tramite il CED, e cioè da quell'organo giudiziario al quale l'ordinamento assegna, secondo anche questa è una tradizione condivisa a livello europeo, soprattutto continentale, compiti di nomofilachia, e cioè di interpretazione uniforme del diritto oggettivo in funzione di certezza del diritto stesso, il che fornisce un'indicazione chiara di come l'idea iniziale non fosse volta a realizzare uno strumento di conoscenza del sapere giuridico autoreferenziale e chiuso all'interno del sistema giudiziario, perché l'esigenza forte, portante, era quella dell'affermazione di un diritto certo e stabile. E questo dà la cifra del collocarsi di questa idea che si è realizzata con la banca dati al di fuori di confini determinati, per rendere tangibile nell'applicazione del diritto e quindi nella costruzione del diritto vivente, del diritto giurisprudenziale che costruisce la norma dettata dal legislatore, quel principio di uguaglianza che è sotteso alla vita democratica di una società civile, per cui la prevedibilità delle decisioni è alla base del trattamento uniforme dei cittadini dinanzi al giudice. Qualche indicazione ovviamente sul funzionamento e sulla portata attuale della banca dati può rendere ancora più chiara questa lettura retrospettiva che ho cercato di dare. Italgiure Web è delineato è costruito per archivi nei quali, secondo specifici settori, è raccolta la documentazione giuridica, in particolare, ma senza essere esaustivi, la legislazione nazionale ed eurounitaria, la giurisprudenza civile e penale della Corte di Cassazione, ciascuna comprensiva di un archivio massime, e cioè della raccolta dei principi di diritto che vengono enunciati dalla Corte di Cassazione ed estratti da magistrati di un particolare ufficio della Corte, l'ufficio del massimario, e un archivio di sentenze civili e penali per esteso. La giurisprudenza raccoglie anche la giurisprudenza della Corte Costituzionale Italiana, anch'essa su 2 archivi, uno di massime e uno di sentenze per esteso, la giurisprudenza dei giudici di merito, quindi dei tribunali e delle corti di merito, la giurisprudenza della Corte di Giustizia Europea e quella della Corte Europea dei diritti dell'uomo. La giurisprudenza ancora delle supreme giurisdizioni, supreme magistrature amministrative, cioè il Consiglio di Stato e la Corte dei Conti, e infine la dottrina, con le indicazioni di dove reperire sulle riviste giuridiche di respiro nazionale gli scritti di approfondimento giuridico e i commenti alla giurisprudenza. Si tratta quindi di molteplici archivi che però sono archivi non separati tra di loro, sono archivi organizzati che consentono di pervenire al cosiddetto dato giuridico globale, che è espressione felice coniata da uno dei primi direttori del CED, ossia il frutto che nasce da una rete di rinvii per cui è consentita la navigazione non solo tra documenti di uno stesso archivio, ma anche tra archivi diversi. Questa è l'interfaccia iniziale di Italgiure Web. Questa navigazione è consentita in base a numerose chiavi di accesso e di ricerca che interagiscono tra di loro, le quali negli anni sono state implementate, sono state affinate, sono state rese di agevole utilizzazione, ruotando al di là di quelle chiavi che si servono di riferimenti identificativi determinati, come può essere l'anno e il numero della legge, l'anno e il numero della sentenza, le parti o l'estensore della sentenza stessa e così via, intorno all'interrogazione per parola chiave, cioè stringhe di ricerca che arrivano a combinare 16 lemmi in forza dei quali reperire le corrispondenze testuali o concettuali sia all'interno dei documenti archiviati in formato Word, sia all'interno dei documenti che sono stati archiviati in formato PDF. Il sistema è poi in grado di elaborare un cosiddetto modello di comportamento collettivo, e cioè di memorizzare le connessioni logiche utilizzate nella ricerca testuale da ciascun utente per poi fornire agli utenti successivi suggerimenti puntuali per gli schemi di ricerca. Alcuni numeri possono essere utili per comprendere fino in fondo l'importanza e le capacità complessive di Italjure Web. Gli utenti registrati al sistema attualmente sono circa 42.000, dei quali gli utilizzatori effettivi nell'ultimo anno circa 17.000, tra cui questi 12.000 magistrati di ogni ordine e grado e per il resto appartenenti alle professioni, avvocati e notai, e alla pubblica amministrazione. In Italjure Web sono archiviate attualmente circa 510.000 massime civili, 162.000 massime penali, cioè i principi di diritto a cui ho fatto riferimento poc'anzi, 400.000 sentenze civili, 531.000 sentenze penali e oltre 750.000 riferimenti di dottrina e quasi 40.000 sentenze per ciascuna delle due corti sovranazionali, Lussemburgo e Strasburgo. Negli ultimi anni l'attenzione si è polarizzata specialmente sulla realizzazione e l'arricchimento proprio degli archivi della giurisprudenza sovranazionale, gli archivi Eurius e CEDU, contenenti appunto rispettivamente la giurisprudenza della Corte di Giustizia europea e quella della Corte dei diritti umani. Questo nella consapevolezza che riveste la conoscenza e la diffusione di tali dati nella costruzione del dialogo tra Corti Supreme e la Corte di Cassazione, che è Corte Suprema, e in vista della realizzazione per l'appunto di quello spazio comune giuridico destinato a essere il più fertile humus per una maturazione dei diritti fondamentali. Nell'archivio CEDU, questo è l'archivio civile, questi sono i vari archivi che interagiscono tra di loro. Nell'archivio CEDU sono presenti in lingua inglese o francese tutte le decisioni emesse negli ultimi anni dalla Corte di Strasburgo, ma per un numero rilevante di decisioni, quelle più significative, il CED della Cassazione provvede alla redazione di ampi abstracts in lingua italiana. L'attività di implementazione dell'archivio avviene al più alto livello, con la partecipazione non solo di magistrati della Corte di Cassazione, ma anche di esperti designati dalla Corte Costituzionale, dal Ministero della Giustizia, dalla Presidenza del Consiglio e dalla Camera dei Deputati, oltre a giovarsi dell'apporto di giovani e selezionati laureati. Tutto ciò non ha distolto il CED dal progetto di massimizzare, secondo una logica che informa l'intero sistema di Italjure Web, di circolarità del sapere giurisprudenziale, anche la più vasta conoscenza della giurisprudenza dei tribunali e delle corti di merito nazionali, attraverso però non una immissione indiscriminata della relativa documentazione, bensì tramite una selezione ponderata dei contenuti rilevanti della giurisprudenza presente su tutto il territorio, e in questa prospettiva è pensata quindi la riattivazione dell'archivio della giurisprudenza di merito, chiamato per l'appunto merito, che è stato fermo per qualche tempo. Da ultimo mi preme poi di porre l'attenzione sulla recentissima realizzazione da parte del CED di sentenze web. Sentenze web è un sistema di ricerca libero, frutto della pluridecennale esperienza di Italjure Web, di tutte le sentenze civili e prossimamente anche delle sentenze penali nel testo integrali della Corte di Cassazione pubblicate negli ultimi 5 anni. È un motore di ricerca innovativo, dalla navigazione assai friendly, accessibile da chiunque, senza limitazioni, attraverso il sito web della Corte di Cassazione, cortedicassazione.it. Come vedete c'è un link di accesso apposito. Il sistema funziona soltanto da fine luglio scorso, ma conta già un accesso giornaliero di oltre 10.000 utenti. Cifra questa che è assai indicativa del successo che l'iniziativa ha comunque incontrato presso una indifferenziata platea appunto di cittadini. A tal riguardo credo che la reale dimensione delle aspettative e dello spirito che ha animato questo progetto particolare sia stata delineata bene dalle parole utilizzate dal primo presidente nella presentazione di sentenze web sul sito della Corte, dove è stato evidenziato come la prospettiva di una sempre maggiore diffusione della conoscenza della giurisprudenza all'interno del corpo sociale, nella quale si colloca il sistema di libero accesso alla recente giurisprudenza di legittimità, non è solo di immediato interesse ma anche di lungo respiro. Non si raccorda esclusivamente a una logica di trasparenza che è pur presente in questa scelta, perché dice appunto il primo presidente, avere la possibilità di conoscere appieno la giurisprudenza della Cassazione è uno degli elementi che concorrono appieno al rafforzamento dei valori della stabilità e della certezza del diritto e quindi alla costruzione di una società migliore. Dunque, e concludo, quell'idea che circa 50 anni or sono, a cui facevo cenno inizialmente, che aveva dato vita ai tal giure web, non era, come ho cercato di spiegare, miope e refrattaria ad aprirsi verso l'esterno, a creare un sistema chiuso solo per la giurisdizione, bensì si è vista essere poi un'idea illuminata, soprattutto vitale, capace di dare forza, tutore e senso a ogni intervento innovativo che l'informatica è in grado di apprestare per la più ampia e migliore diffusione del dato giuridico. E dei risultati sin qui raggiunti, devo dire che la Cassazione italiana è particolarmente orgogliosa. Grazie.
Thank you very much for this presentation relating in particular to the data bank in the court, the Supreme Court. And it showed in a very clear way that on the one hand, it facilitates access to law, and on the other hand, it ensures the stability and forcibility of the judgments in Italy, and what is extremely important, in fact. So with this, I think that we finalized the three interventions about the situation of the Supreme Court, and we can go, as indicated in the program, to a period of questions and questions with answers. And please feel free if any of you would like, apart from questions or specific answers from this side, if you want to say a word about your internal system, don't hesitate to say if it is relating to the Supreme Court. What I would like to ask you is that please, if you wish to ask questions to the table, please indicate your name and your function, and we will take the questions by group of 3. Please, you have the floor.
We kindly ask you to go to the podium, please, since we have some problems with the microphones right now. We'll bring you radio microphones on the afternoon. Thank you.
Hello, my name is Simone Cuomo. I work for the CCBE. I have a question for Judge Jean concerning the very interesting overview he gave about the French e-justice system. I was wondering to what extent these tools are also available for foreign lawyers that practice under their home title in France in this system.
Thank you for this very interesting question. Any other questions? Very good. Yes, please. If you don't mind, again, to take the floor on the microphone. very electronic.
Hello, I'm Alessio Pellegrino from Italian Bar. I have two questions to the Supreme Court of France. I would like to know if the database of the judge, the access of the database is by username and password, or is it necessary and digital certificate to ability to have access on the console. And yes, you said electronic signature, but is electronic signature or a digital signature? Is it different for us to know? Thank you.
Very good. We still have space for a third question. Please, if you don't mind to take microphone.
Oh, yeah. Thank you. My name is Stephen Mason.
I apologize, but the lady already asked for the floor. Please.
Buongiorno, Eleana Fedele, Corte di Cassazione. Una domanda per i nostri ospiti, inglese e francese. Abbiamo visto l'importanza che l'Italia attribuisce al sistema di pubblicità delle sentenze, da ultimo divenuto pubblico anche per i cittadini. Come in Inghilterra e in Francia viene affrontato il problema della compatibilità della pubblicità delle sentenze con la protezione dei dati personali, tema di cui abbiamo anche accennato stamattina. Grazie.
Grazie a lei. Mr. Mason, if you don't mind, we will have the three answers now, and then we will come to a second round. Thank you. Monsieur Jean, vous aviez la parole.
Merci, thank you. I'll try to give an answer to the three questions. Yes. And perhaps if you speak very excellent French, I think, to help me if necessary, yes. If necessary only, but if you have some precision to give, yes. For foreign lawyers, you know the difficulty for French people to communicate with other people. So I think we are a little weak for on our website about translation of French decisions. You know that the decisions from Court of Cassation are very difficult to read. For an example, European Court of Strasbourg it's very difficult to understand the technical, the writing technical of French decision, because it's from the 19th century, the same, yeah. And the Prime President gave me a mission, and he asked me to lead the reflection of the Court of Cassation, how to motivate the decision, the ruling, to be most comprehensive. Yes, it's a huge work, very huge work, because we have many conservative people and it's very difficult. But we have another generation which agrees with this evolution. So it's difficult to understand in our country. So it's very difficult for foreigners to understand the communication of Court of Cassation. So as you do in the UK, we have some press communication for press, and we explain with summaries. We explain our decision, but it's a real difficulty. So the second difficulty is translation. We try to translate the most important decision in English, in Arabic, in Spanish, in Italian, some of them, but it's very costly. Translation is very costly. So I think it's a problem, and we try, but we have, as in any European country, we have financial problems. So we try to make economies and not new expenses. So translation is very expensive. So it's, I think it's a major problem. The second question, it's about database for users. Yes, we have a certificate for authentify the person, not username, but certificate for identification. And the the third question was about application and the compatibility about public decision and the name of people. We have very important work, and it's very costly about, I don't know the word in English, anonymization. It's anonymization, yes. We not to not identify people, and we have an application, a special application to anonymize decision. But we try with the Conseil d'État to have the same application, and it's the same, it's very costly, but we try to reduce the cost, but all decisions were on the website are anonymized. But the problem, what is anonymization? We can delete the name, okay, but we have to delete also the Christian name. We have the number of bank account, yes, the address of the person. So we are now, we have not the same level of identification that the Conseil d'État. We try to go in depth in the anonymization process, but the more you go in depth, more it's costly, because you have to delete many information. And it's the most important for criminal cases. Because if you have the address or the call number in the procedure, yes, you can recognize the people. The name of the factory, for example, and so we have very famous cases, as it's very difficult. So I think it's the same in the other countries. So our priority is to have all the decision of the website, but we have to consider it with respect of anonymization of persons, yes. But we can always recognize. In a criminal case, you can recognize famous people, but in a divorce, yes, we can recognize. It's difficult to say. When I was an advocate general, I was a first of chamber. It was a very important divorce with millions of euros. Yes, and this decision is on the website. And if you know that this person lives in some countries and is married with people who lives in the other country, you know the lawyer, you know the the juridical problem. The problem in the property is the problem of use of the name of the famous person for publicity. Yes. So you cannot anonymize this decision. Yes, but you have two levels. The first level, the name, the call number, and after you have the information in the public. You have in the news, so you have in the case law. Yeah.
Thank you. Please.
Quanto a quest'ultimo aspetto, era solo da rimarcare che la recentissima esperienza di sentenze web ovviamente si conforma alla legislazione italiana che prevede dei criteri di selezione particolare, oltre al fatto di dare delle direttive più generali quanto ai dati sensibili, ma muove essenzialmente da una scelta a monte che proviene dai giudici che fanno quella determinata sentenza e individuano il caso cosiddetto da noi da oscurare. E ovviamente la problematica è molto più complessa, perché la legislazione italiana, che parte dal 96 2003, ma potete comprendere che è un mondo che viaggia molto più veloce di questi tempi, seppur per quanto riguarda il legislatore relativamente stretti, per cui il problema di oscurare, di rendere non rintracciabili, e soprattutto il problema della indicizzazione dei dati attraverso ulteriori motori di ricerca è un problema forte che la Cassazione italiana si è posto e continuerà a porsi nell'immediato per risolvere la questione, ovviamente nel bilanciamento di interessi che vede da una parte forte il diritto fondamentale che inerisce alla protezione del dato personale, ma dall'altra parte un'esigenza altrettanto rilevante quanto alla conoscenza del dato giuridico e dei contenuti giuridici a cui facevo cenno prima, che servono anche per la costruzione di spazi giuridici comuni.
Grazie, Lord Kerr.
Well, I think that the third question was probably directed to all three of us, and I conceive that to be the only one that I'm required to answer, but perhaps I can be forgiven for saying something about the first question, and that is the accessibility of the materials that are generated by the Supreme Court to the public in general and to lawyers of foreign jurisdictions in particular. Our UK Supreme Court website is freely available to all, and on the website, by entering the name of a case in the decided cases box, you can get instant access not only to the particular judgments in the case, but also the press summary and what's known as the bench memo. The bench memo is a document which is prepared in advance of the case by our judicial assistants, which will outline the issues in a particular case. That's freely available to members of the public who visit the court, so that they can have an idea of the type of arguments that are going to be presented. So far as the use of technical language is concerned, this is, I think, a perennial and universal challenge for all justices. It's rather better recognized now than it was perhaps in the past. Our obligation, as it seems to me, is to deliver judgments which are comprehensible to a lay audience. In the United Kingdom, we are considerably assisted by our young judicial assistants, whose tasks are many, but one of the most formidable tasks that they must confront is to reduce often highly technical, not to say arcane language into a digestible summary which an ordinary member of the public can understand. And this they perform extremely well. So far as anonymization is concerned, that is a very interesting and a very difficult question. The United Kingdom Supreme Court, because we stream our proceedings live, has to confront that question before the proceedings take place. And therefore, we encourage the parties to make application to the court before the hearing if they consider that certain aspects of it must be remain confidential or must be anonymized. Because, of course, in the course of a hearing, counsel may inadvertently refer to the name of a party whose name should remain secret. This is a particular problem in refugee cases, where many of the applicants for asylum don't wish to have their names revealed, because if they're ultimately unsuccessful in their asylum applications and are returned to their country of origin, the very fact that they have made application for asylum may be something which will cause them considerable difficulties. So we generally try to deal with difficulties in relation to the non-disclosure of confidential material before the case begins. After the case is completed, however, the court, being the data controller for information which it has received in the course of the proceedings, has a legal obligation to ensure that data which should not be revealed is not disclosed. And this is a particular problem for us, because traditionally, all of the material that is generated by an appeal in what was formerly the House of Lords and now the Supreme Court is of acute historical interest. And many institutions are extremely anxious to have access to that material, largely for posterity purposes. And they will apply, particularly the Inns of Court, university libraries and the like, will apply to us to have the material made available to them for their own archives. Before the data protection legislation came into force in the United Kingdom, that did not give rise to difficulty. And there is a very considerable corpus of material in many of the academic institutions in the United Kingdom, which is focused directly on documents that were produced for the purpose of the hearing before the final Court of Appeal. Now we find that we have to comb through the documents in order to ensure that our legal obligations under the Data Protection Act are not contravened. And that, as has already been said, is an extremely time-consuming and costly exercise. And we have found that it is impossible for the United Kingdom Supreme Court to undertake this from its own resources. So what we have done is, when we receive requests to produce documents which have been generated by an appeal, we inform the institution that we will make it available, but that they must provide trained lawyers who can examine the documents to ensure that our responsibilities under the Data Protection Act are provided. This is a proposition which is not without controversy in these times of economic constraints, but it's a problem that we are trying to confront, and for which I'm afraid I must say the perfect solution is yet to emerge.
Many thanks. We still have time for 2 questions, and perhaps I would give the floor first to Mr. Mason in the first place, and then for you as a second place. So, Mr. Mason, first you have the floor.
Thank you very much, Fernando. First of all, an observation, if I may, please. I have been publishing translations of cases, important cases, in electronic signatures and electronic evidence since 2004, from languages such as Portuguese, Norwegian, Danish, Polish, French, German, and Italian. And in fact, I'm publishing 4 French cases this year in my journal, So, Judge Jean Bourgine, you're quite correct to say it is actually quite time-consuming and expensive to translate cases. However, I've been doing this on a voluntary basis between me and a native speaker, and I hope that the quality of the judgments that are available free online demonstrate that. If I may be permitted to ask all of the panel if they would be allowed to comment on something other than the use of electronic evidence or electronic media in the actual Supreme Courts, and to widen the discussion very briefly on the need, in my perception, for education of lawyers in electronic evidence, because I have been writing about this subject now for almost 10 years. And what strikes me is that there is a great deal of ignorance amongst lawyers about the issues relating to electronic evidence, and that comes over in quite a lot of the judgments, not just in England and Wales, but also in other European jurisdictions as well. And last year, I persuaded 2 academics, one in Singapore and one in England, to write articles as to why electronic evidence should be taught. And I would be interested in the views of the judges here today. Thank you very much for hearing me.
Many thanks. We still have time for a second question, please.
Sì, sono Antonio D'Amato, sono un magistrato del pubblico ministero, ma sono qui oggi in qualità di delegato del Consiglio Superiore della Magistratura, in particolare presidente della 7ª commissione del Consiglio Addirituro, che è una commissione consiliare che si occupa proprio dei profili relativi all'organizzazione degli uffici giudiziari. Volevo fare una domanda a Messie Jean con particolare riferimento ad un passaggio del suo interpretativo anche del processo penale. Noi diciamo in Italia siamo molto interessati perché diciamo che in Italia c'è il processo civile telematico che da poco sta esordendo, il processo penale telematico è qualcosa che di là da venire, forse un barlume di processo penale telematico potremmo individuarlo nella prossima entrata in vigore a dicembre del 2014 delle notifiche penali telematiche per le parti diverse dall'imputato. Fatta questa premessa volevo chiedere, questa smaterializzazione del processo penale in Francia riguarda il dibattimento, anche la fase istruttoria, e se può Messie Jean gentilmente illustrare qualche profilo del processo penale appunto relativo alla smaterializzazione e chiedergli soprattutto quanto tempo ha impiegato la Francia per realizzare questo obiettivo. Grazie.
Grazie. Nous avons encore 5 ou 6 minutes. Et dans ces 5 ou 6 minutes, we have still 5 or 6 minutes, and in those that period of time, let's see if first you, Judge Jean, you want to reply to both questions in the first place before giving the floor to the table. Please.
Perhaps I want to answer to the last question to criminal cases and just add from my previous speech for motivation of and the relation with university, because it's very interesting, I think, for translation and access to justice. Just one sentence. I like a sentence of my colleagues from Belgium. They say for the sentence, what is the principle of a decision? And the Belgians say, what is the role of a judge? To say the law and to be understood. To say the law and to be understood. Yes, French people don't respect this principle. Yes, today at the Court of Cassation, I think they say the law, but they are not understood, yes. Now the answer for the criminal cases, for criminal cases. We have two levels which are very different. At the level of the Court of Cassation, the case of the criminal division is the only exception to the dematerialization. Why judges and prosecutors general have not the dematerialized documents? Because we have not the representation by a lawyer is not compulsory. So people can go directly to the Court of Cassation. So we cannot oblige people to have a computerization of their file. It's not possible. Yeah. But at the level of the Court of Appeal or out, we have dematerialized file in PDF version, no problem. And I've been in criminal process, we have with a CD-ROM, we have with our computer, we have all the file with each, which is dematerialized, no problem. Preliminary inquiries and the sentence and so on. So, but it's different at the Court of Cassation level. But the judges, the reporting judge, use also conclusions of the lawyers and the Court of Appeal decision. He can work with dematerialized file. And the decision is also in dematerialized version, but we cannot work with all cases. When you have not any lawyers, we send a paper decision. But for when we have a lawyer, we work with a dematerialized version. Okay, it's my answer.
Well, many thanks. Lord Kerr.
Well, I think the only question that I can address is the question of the training of lawyers in the use of electronic evidence. As a judge, I suppose I'm congenitally in favor of the training of lawyers in any area of law. Electronic evidence, of course, covers a very wide, or potentially covers a very wide spectrum. And as an appeal court judge, I'm not accustomed to dealing with evidence because the evidence, by and large, will have been found and conclusions upon it will have been reached before the case comes before the court of which I'm a member. But I am aware that certainly judges do undergo training not only in the use of electronic equipment, but also in the technicalities which comprise the computers that we use on a daily basis. And from time to time, we've had to deal with cases in which a knowledge of the workings of computers has been vital to an understanding of the issues and the conclusions that we reached upon them. Professor Richard Susskind of the United Kingdom is a special advisor to the Lord Chief Justice of England and Wales, and he regularly gives lectures to members of the judiciary. I have attended them. I can't claim to have understood all of them, but what I have understood has been of enormous benefit to me in dealing with cases where technological issues arise.
Many thanks.
Grazie. Sulla prova elettronica posso che condividere le parole di Lord Tonamore, perché anche la Cassazione italiana non acquisisce prove e quindi ha problemi di valutazione della prova. Questo comporta ovviamente un background di formazione forte da parte dei giudici e degli avvocati e degli attori processuali che ridonda anche sulla formazione dei giudici di Cassazione, sulla valutazione della prova elettronica e dunque su quelle regole che per ora quantomeno nel processo civile sono all'esterno del codice che raccoglie le regole processuali proprie, perché vi è una regolamentazione specifica della tipologia di prova elettronica in quanto tale, ma viene raccolta come prova documentale e quindi deve essere valutata secondo quelle regole tecniche che stanno all'esterno delle norme procedurali. Questo quindi comporta una necessità di forte specializzazione da parte del giudice nella conoscenza della regola tecnica che è all'esterno e che quindi deve essere poi interpretata alla luce della cultura giuridica che possiede il giudice.
Grazie. Very good. So I think that we came to an end to this extremely interesting panel. I think that we can say that we are very pleased and honored to have so high representatives of the judiciary and to speak about e-justice and to show us, to all of us, that e-justice is already a reality in the Supreme Courts. And also many thanks to the audience for their contribution to this very good debate. So I think that Julie would like to say a word about the follow-up, and thank you very much for this interesting discussion. Thank you.
Grazie al Presidente Pereira perché ci ha fatto fare la figura non dei soliti italiani che non rispettano gli orari, ma siamo molto grati perché invece stiamo rispettando gli orari. Allora, adesso abbiamo il lunch break, sempre nell'aula Gian Lombardo qui a destra, quindi usciti a destra per chi è arrivato dopo e non ha potuto fruire del coffee break. Alle 2:30 puntuali iniziamo le due sessioni parallele, una è qui e l'altra è nell'aula della Torre al quarto piano. Ci sono le indicazioni qui sulla sinistra, seguite della Torre, of the tower, la traduzione che forse i traduttori stanno facendo, e quindi vi potete dividere e seguite semplicemente le indicazioni, cerchiamo di rispettare gli orari. Poi alle 5:30 abbiamo la visita alla parte monumentale di questo bellissimo palazzo, grazie alla grande collaborazione e l'aiuto delle funzionarie della Corte di Cassazione. Alle 7:30 abbiamo organizzato un trasferimento in pullman, in bus, da qua fuori, cioè dalla parte di Piazza Cavour, dove ci sono dei pullman che ci porteranno alla cena di stasera, facendo un giro turistico ovviamente abbastanza rapido, ma secondo noi carino, in cui un po' vi spiegheremo, insomma andremo a vedere il Quirinale, il Colosseo, il Vaticano, insomma non ci andiamo diretti ma ci prendiamo un giro un po' largo. Noi ci siamo segnati quando siete arrivati chi è che viene alla cena e chi è che vuole usufruire di questo trasferimento col pullman. Chi cambia idea può venire lì al tavolo, al desk qua fuori e dircelo se non l'ha già fatto. Siete ovviamente tutti i benvenuti. Mi sembra che... No, sì, alle 7:30 l'autobus partirà non dove siete entrati, ma in Piazza dei Tribunali. Però se ci seguite comunque ci andiamo tutti, quindi non piace al mio capo, ma lo dico io, tanto insomma, mi riconoscete comunque, ok? Grazie ancora a tutti, buon pranzo.
Good afternoon. If you please take your seat. Thank you. Okay, good afternoon, ladies and gentlemen. I'm very pleased to be the convener and to welcome you to this session on comparing some national justice systems. The Research Institute on Judicial Systems of the Italian National Research Council has a long record of study and research on the development of information and communication technology in the justice environment. So I'm very keen to listen to you with updates on what's going on in Europe. In order to get the most of our 75 minutes session, we agreed together to focus only on one up and running application for each country. So I hope at least that will give you the sense of what's going on in these countries. The presentations will single out the factors that have been the key drivers for their success, hopefully, along with the problems that were addressed and solved. We'll try to do our best to stay on track with the schedule. So after the 4 presentations, I hope there will be some time for questions and answers. We have 4 distinguished speakers here with different backgrounds, which makes also this session quite, I think, interesting. They are Thomas Kexel from North Rhine-Westphalia, Germany, Timo Ligi from Estonia, and Christine Lewis from the United Kingdom, and Giulio Borsari from Bologna, Italy. So Thomas is the first one. Thomas is a judge. He worked in different positions in several courts with a special focus on judicial administration. Since 2010, if I'm not mistaken, he's the head of the Minister Office and personal advisor of the Minister of Justice of North Rhine-Westphalia in Düsseldorf, Germany. Thomas, the floor is yours.
Thank you, Marco. This one?
Yeah,
okay.
That's fine.
Okay. Yeah, thank you, Marco. Just have to. So, dear ladies and gentlemen, dear colleagues, I decided to present you the business register solution for Germany. The last financial crisis has highlighted once again the importance of transparency across the financial markets. Okay. Including on companies' governance and business activities. Electronic business registers are an important cornerstone of a stable economy of each country. Several studies throughout Europe confirmed that improving access to up-to-date and trustworthy information on companies could encourage greater confidence in the market, help recovery, and increase the competitiveness of business. Business registers play an essential role in this regard. They register, examine, and store information on, for example, a company's legal form, its registered office, capital, legal representatives, and annual accounts, and they make this information available to the public. Businesses are increasingly expanding beyond national borders to seize the opportunities offered by the single market. Progress in the field of information technology is making it easier for citizens and companies to purchase and sell goods and services abroad. Cross-border groups, as well as many restructuring operations, such as mergers and divisions, involve companies from different member states of the European Union. Furthermore, over the past decade, the case law of the Court of Justice of the European Union has opened up the possibility for businesses to incorporate in one member state and conduct their business activity partly or entirely in another. Accordingly, there is increasing demand for access to information on companies, either for commercial purposes or to facilitate access to justice. Access to business information requires cooperation between national and cross-border business registers. Some such cooperation already exists, but it is limited to certain types of information and does not cover every member state. It is therefore not sufficient to meet the needs for information induced by business activity in the single market. But efficient national and cross-border cooperation between business registers is not only essential for the smooth functioning of the single market. It also reduces costs for companies operating across borders. With the following slides, I will give you an overview about the national solution in Germany and the German National Business Register portal. Yeah, you see Germany there. And our public business register is kept by 130 local courts in all the 16 states. Entry in the register is compulsory for nearly all forms of companies under German law. All in all, there are 4.6 million registered entities, including merchants. All business information is available via the platform Gemeinsames Registerportal der Länder. As you see, 4.6 million entities and more than 1 million just in North Rhine-Westphalia. I have to be proud of it. So, electronic business registers are kept and accessibly fully electronically. The historical documents got scanned and stored in the company file. And the slide says there is one technical system in Germany. Well, that's the nearer future. At the moment, there exist two end applications to store and administer the business register's data, which will be replaced 2017 by a converged single end application. This is the one technical system. The German Business Register provides reliable information on status of companies, their legal representatives, share capital, and so on. Entries solely based on notarized applications provide full proof of their content. Additionally, it serves as a repository for important corporate documents that are accessible via the common portal Gemeinsames Registerportal der Länder, www.handelsregister.de in the internet. So let's have a look for the electronic procedures. I make this so. Access to business registers is granted only through a notary, who identifies the applicants, especially directors of the companies, digitizes the documents and guarantees the complete, accurate, and valid content of the data that is to be registered. Applications and other documents, for example, applications for registration, shareholder list, and so on, are submitted as electronic notarial deeds and exclusively accepted in electronic form. Apart from the digitized notarial deeds, notaries have to provide additional structured, machine-readable data to enable a quick entry and to increase productivity in register documents. Thus, entries into the business register is no longer a bureaucratic obstacle, but a cost and time-efficient service rendered by notaries and courts. The applications are submitted via EGVP, a specially designed software based on OSCI Transport, a standard for secure, confidential, and legally binding transmission of messages, assuring integrity, authenticity, confidentiality, and traceability. So now just have a look at the portal itself. You see the starting site, starting website. It's an easy access for everyone. It's one site and it's an all-over search with some options to detail the search. And here you see some search results. So all kind of relevant current or historical company information is accessible via the portal. To understand the importance of the register, the information registered has legal force, public trust. For example, anyone can rely on the registered information, whether it is actually accurate or not. We know this as positive public trust. And anyone can also rely on the absence of facts that are not registered, negative public trust. So, the principle of this public trust is only viable as the information in the register, evaluated, checked, and submitted by a notary, can be relied on as a legally and factually accurate, complete, and current. The commercial register provides access to relevant information concerning commercial enterprises, name, authorized representatives, share capital, etc. That's on this side. As well to all documents submitted to the business register. For example, applications for registration, shareholder lists, articles of association, agreements regarding the reorganization of companies, etc. So here you see the statistic downloads per month of our business register. With this slide, I want to highlight the importance and acceptance of the German register portal. You can see that during the high time of the last financial crisis, the number of hits to the website increased significantly. 18 million a month. 80 million hits a month. The average today is about 8 million a month. So let's come to some actual development. In addition to the above mentioned documents, relevant information concerning commercial enterprises, name, authorized representatives, and so on, will be available as a machine-readable download as structured data. Thus, business information can be, on single demand or via APIs, exported and processed by software of operators in a host of different areas. For example, public prosecutors, lawyers, banks, tax offices, and so on. Amendments necessary due to the transposition of Directive European Union 2012-17 will be the implementation of an European unique identifier, the elements of which are specified in the directive. It will be an intelligent register number, that is, the company's origin and registration authority will be identifiable by reading it. Additionally, information of the global legal entity identifier introduced 2012 for companies dealing on the financial sector, respectively with financial products, will be supported. Some next steps in the near future. These are the next steps and further services planned for the German business register. There are services like web services for transmission of court fee information, newsletter service, RSS feeds. And besides that, we are thinking about technical solutions to interconnect the register directly with the back office solution, for example, for public prosecutors or something. All of these topics will help to increase the transparency for the economy. So we work on new interfaces. As mentioned above, application programming interfaces are partly in use. It's called Bundesanzeiger, and will be defined as a generic interface for every kind of back-office solution regarding all available register data. One example. At the moment, it is envisaged to connect the Federal Motor Vehicle Office, we call it Kraftfahrtbundesamt, KBA, via API with the business registers, thus implementing e-licensing for companies. The KBA software will check automatically if the person who wants to register a company vehicle is authorized to do so, whether he is a representative of the company or authorized by a representative. In accordance with the directive, with the known directive European Union 2017, messages and information from foreign registration authorities regarding transfer of seats, cross-border merger or branch disclosure events will be time-efficient processed into the register without having to make any changes to the data. Supervising authorities got connected and thus guaranteeing transparency of company information, business transactions and group structures. Now we have the link to e-Codex with the interconnection. There are approximately 20 million companies within the European Union, all registered in the various business registers of the member states. Businesses increasingly expand beyond national borders, and supranational companies, as well restructuring operations, whether it be a merger or a division, always involves companies from different member states. Cross-border operation and interconnection of the national business registers is thus indispensable. In this context, Germany, France, Ireland, Italy, and Austria have decided to pilot various use cases in the field of business registers. The necessary e-Codex infrastructure is already installed in the piloting countries. I hope so, I think so. The first piloting phase sees the fully electronic exchange of information between the national business registers in case of cross-border mergers. It has just started, I think, in this year, in this semester. In the future, instead of a complicated and time-consuming paper-based communication process within international regulations, the necessary certificates and messages will be transmitted fully electronic. The communication between the authority business register e-Codex infrastructure. This means messages will be transmitted to the corresponding authority via national gateways and connectors. A directory of registers currently ensures the proper electronic addressing to the foreign business register authority in the end application. The gateway provides the technical and organizational e-Codex infrastructure for incoming and outgoing cross-border electronic communication. And now something for the technicians. The gateway, it is based on OASIS, EBMS 3.0, AS4 ETSI-RAM evidences, which ensures a secure exchange of messages. The connector is an interface between the national e-justice infrastructure, which processes the document to be sent, and the national gateway. Furthermore, it contains a security library, conducts the mapping of the structured content of the messages into national XML standards, and creates the so-called Trust OK token. The Trust OK token, being generated by the sending connector, contains a PDF, the result of the signature and certificate validation or information regarding the authentication process of the user. Additionally, a machine-readable form XML file will be generated to support future developments. So, ladies and gentlemen, this builds a common infrastructure based on widely accepted international standards. These standards can be reused in an easy way, not only in the area of e-justice. Within the e-Codex project, with your strong support, these solutions can and will be extended to further member states and associated countries. With the support of legal practitioners, we can together increase the effectivity and efficiency for e-justice in whole Europe. Thank you for your attention, ladies and gentlemen.
Thank you very much, Thomas. It's now I move to Timo Ligi. Timo has a background in law and public administration. He has been working in the Estonian Ministry of Justice since 2002 on several positions dealing with court administration, case management, and information technology in courts. He has also served as an expert in several foreign projects. It's Timo, the floor is yours. Thank you.
Thank you. Good afternoon. I will talk about the Estonian e-justice system called KIS2. KIS stands for Court Information System in Estonia. Number 2 means that it's the second generation of information systems in Estonia. And we have been working on it for the past 5 years now. And it's now fully implemented in the Estonian court system. I will just quickly go through the history of information systems in the courts of Estonia. As you can see from the slide, KIS2 in fact is actually the third information system which has been used in the courts of Estonia. The very first one, called Kola, was actually a very basic information system. It was only used to publish judgments on the internet and to gather statistics for the Ministry of Justice. So this means that it didn't really offer much to the judges or the court clerks in terms of simplifying their work. But we have now come to KIS2, which we ourselves consider to be a modern document management system for the courts. As I said, it's now been fully implemented. We started with the process already in 2010 with the needs analysis, which also involved representatives from the courts, judges, ordinary court clerks, who now actually work with the system. We had 6 months for this analysis, then 6 months for procurement process and contract negotiations. And then we developed for 2.5 years before finally, in September last year, we went live. And we started with a pilot, actually from the end of September last year until February this year. We only had 2 courts who were using the new information system. And then from February up until June, every 2 or 3 weeks, we had a launch in one of the courts of Estonia. So we basically implemented it step by step. And by June this year, the system was implemented, and also the Supreme Court now uses the same information system as the courts of the first and the second instance. Earlier, or up until June this year, the Supreme Court was using their own separate system. Just a quick overview of the most beneficial functions of the new information system. It enables more complex allocation of cases. This means that it allows to take into account not only the caseload of a particular judge, but also the workload. In Estonia, judges have agreed on a system of weights. Each category of a case has a certain weight, and these weights have also been, the data regarding these weights has also been inserted into the court information system. For example, a labor dispute is 10 times as time-consuming as a divorce. So when you allocate cases to judges, and when judges want to specialize specifically, it's sometimes quite useful to allocate cases, not taking into account the number of cases, but actual weight of the case and the workload which is associated with adjudicating the case. This system allows the courts to do that. It's possible to allocate cases based on the case number, also based on the workload. And the system allows automatic generation of documents using the data which has been inserted into the system already previously regarding the case, like the participants of the case, case number, the judge who's dealing with the case, etc. Each user of the system can elaborate or come up with their own template. And you can also have universal templates so that, for example, certain court orders can look exactly the same throughout the entire court system. But if necessary, you can have personalized templates. The system is linked to Microsoft Outlook so that the calendaring functions are combined with Outlook. The system can send out emails to participants, and all the emails which have been sent to the official email address of the court are also automatically sucked into the system, so that there's no need to upload them manually. It's possible to, in Estonia as well, we have this rule that in certain cases you you cannot publish certain judgments with the personal data of the participants, like names and identification codes and contact data as well. And this new information system enables automatic replacement of this data with symbols or letters X, however you want to replace them. It's of course it's not 100% like foolproof in that sense that the Estonian language is quite complex, and you cannot the name, how you actually write down a name can vary depending on the sentence, and sometimes this system cannot replace all the names properly, but at least it makes it a little bit easier. The system has links to the most important registries which the court clerks and the judges are using in their everyday work, like the population registry, business registry, real estate registry, the tax authorities registry. And for us, of course, it's also important that it's a unified and single information system for the entire judiciary. And before I go further, just a drawing of how this new information system actually works. It is all based on the central information system called the e-file. So, for example, if a criminal case is started by the police, they enter some data through their own information system, and it all is stored in the central e-file database. The prosecution then probably adds something to the same case. The courts, of course, also add to this particular case. They certainly at least upload the judgment, for example, if a person is convicted or not. And then it ends up in the information system of the prisons because they deal with the prisoner. So, in fact, the new information system is more or less like a user interface for e-file, where we keep most of our data. So there's no need to actually enter the same data over and over again by different state authorities. By the end of this year, the system will have cost us about 2.6 million euros from the very beginning, from 2010. And then in the very beginning as well, I would say in the end of 2010, we asked the court clerks that if you had this kind of an information system with all these functionalities, how much time could you actually save by using this system compared to the old one? And then they estimated some savings, and based on these savings, we kind of came up with a possible number for benefits. I'm quite certain it's overestimated. I'm quite certain that the system does not pay for itself within a year, but I would say that this system should pay for itself within 2 or 3 years. And finally, some slides about lessons learned. I have one slide for what went well and 2 slides for mistakes. So we definitely made some serious mistakes as well, but I will honestly tell you all about them. What I think went well was definitely the fact that we involved the end users from the very beginning, the judges and the court clerks. We had a group of 20 or 25 people from the courts, from different positions, from different courts, already involved in the needs identification phase and the analysis phase. And then when we started to develop the system, we again kept the same group close at hand, and we used them for testing. And we also used some representatives from the same group for training other court staff. And we will again use them to set up this system of senior users, which would work all over Estonia in all the courts to support the staff on the spot, so to speak. Secondly, what I think was a success was this idea of a step-by-step implementation. We implemented a court or a courthouse at a time. The previous court information system, KIS1, was implemented like, at one instant or entire Estonia at the same time. And it was quite painful. So as we don't have a very huge or a very large team, we thought that this time we would try to implement it step by step so that we could focus on each of the new group of users. It would require us less resources as well. And we spent quite a lot of time in the courts during the first couple of weeks after the launch. And thirdly, I think we have managed to implement some changes to the work processes through the use of IT. I already mentioned that the system can send out emails, and it's quite a simple thing, really. But what it means is that all the data regarding about the fact that an email was sent out to a particular participant is generated automatically. You don't have to actually register a letter. And another thing from the same kind of same idea is that the court submits quite a lot of the data which is generated by the judgments. I already showed you this drawing about the e-file, but this means basically that when a court makes a judgment and sentences somebody to prison, then the sentence is actually entered by the court like a metadata. And this is transferred to the information system of the prisons. Similarly, if a court orders somebody to pay a certain amount of money to the state, this data again is entered by the courts, and then it's transferred to the information system of the tax authority. So previously we had other people entering data which comes from the court judgments. They didn't actually work in the courts. And it caused quite a lot of mistakes because not always the judgments are very clear, and not everybody can read them as they're supposed to be read. So for us, it's very important that actually when the court decides something and it's relevant for the other state authorities, that the court also enters the data into the information system. Now about the mistakes. The first and big mistake was that we changed the user interface, or how the user interface looks like. We had already KIS1, and even though we were not entirely satisfied with it, I think we should have kept the new information system also looking like the previous one, in that sense that the main logic of how it works should have been the same. Where you have certain like menus and stuff like that. This is what, for example, huge developers like Microsoft and all the others, how they introduce new versions of their programs. They never actually completely change how the old program looks like. For example, like how Microsoft PowerPoint looks like. And we did that, which was a big mistake because we had to put more effort on training, and it took much more time for the end users to get used to the system. Secondly, we should have developed the data transfer from the old system to the new system hand in hand with the actual development. This is slightly technical, but this means we actually, what it resulted in was that we found out about some of the problems regarding the speed of the new information system at a quite late stage. And we are now dealing with it, but we could have avoided all these mistakes if we had started with the data transfer slightly earlier. Thirdly, we didn't have enough professional testers. We had the testers from courts who were themselves court clerks. And we had some professional testers, but we should have had more, because the fact is that court staff, I mean, they're not the best testers in that sense that they focus on their own line of work. And it means that some parts of the system may remain to be untested if you don't actually have a lot of professional testers who can go through all these corners, so to speak. We should have implemented the minimal version of the new information system as soon as possible. As I said, we developed the system for 2.5 years before we finally went live. And I think it's too long. We tried to offer quite an advanced information system already when we started the pilot, but we could have just went live with a very basic one, which more or less does the same stuff as the previous information system, because with these new functionalities, it takes time. Users don't really start using them immediately. They have to get used to them, and then they will start using it. So there's no sense in coming up with all these new great things if nobody is using them. And the last mistake is, again, slightly Estonia-specific, but I will go through it anyway. Maybe its moral is useful for other countries as well. As I said, we had pilots. We had we had courts which were using the old information system and courts which were using the new one. And at the same time, we have this web portal called the public e-file, through which participants of the proceeding can submit documents to courts. And they can also view all the case documents if they log in to the web portal. And if a court has made the document deliverable to these participants, then they can receive the document, and the data regarding the delivery goes back to the court. And this web portal was attached to the old information system, to the old KISS. But in order to provide the same service to the users of the new information system, we had to have regular data transfers from the old system to the new one, and back and forth, so to speak. We had data transfers from the old system to the new one every 24 hours, and transfers from the new system to the old one every 15 minutes. And even though we invested quite a lot of money and time into it, the data transfers actually didn't work very well. There were some documents which were uploaded by the users of the new information system which weren't visible to the participants of the proceedings. Some data didn't also transfer back to the users of the new information system, so it was basically quite a big mess. So instead, what we should have done is we should have just said that during the implementation phase, or during the piloting, this service of public e-file is not usable by those whose case is heard in the courts which deal with the new information system. It's a parallel also from, for example, other projects of infrastructure, like if you have road works, or if somebody repairs roads, then also you tend to close down some parts of the roads at least temporarily. You don't actually build a new bridge over the road just for the time of the repair works. In the end, nobody was happy with this. So, thank you. I just would like to sum up by saying that I think replacing information systems with new ones is much more difficult than launching the very first information system. We definitely thought it's much more easier, and now we have learned that it's very, very difficult. But nevertheless, you should try to provide the best information system for the courts, even if it means some kind of crazy period in between. Thank you.
Thank you very much, Timo. Christine Lewis is currently working as head of strategic alignment and the Ministry of Justice in London. Prior to joining the Ministry of Justice, Christine held a number of enabling leadership posts after over 20 years supporting technological aspects of higher education at University of Nottingham. Christine, the floor is yours.
Thank you. And just while we're waiting for the slides to come up, to say that we've been asked to talk about a successful and up and running system, which actually quite limits it for me, because we're in the middle of a big transformation of the whole of our digital system, but we're mostly in piloting stages. And we actually really only have one that I'm going to talk to you about, which isn't in the criminal justice system, but it's going to give you a really good example of how we are going to digitize our systems. So I'm going to talk about lasting powers of attorney, which is part of our Office of the Public Guardian. It's the very first of 25 cross-government digital exemplars that's passed what they call a digital by default service standard. So we have a big drive from our government to process all government services digitally, and we're supported by the Government Digital Service in this. So it's the very first one that's gone live. And just to cover a lasting power of attorney, it's a deed that's put into place to appoint people to manage your affairs if you were to ever lack the mental capacity for this. We have two strands for it, health and welfare, and also the property and financial affairs. But the main aim for all of this is to make it faster, easier, and cheaper for our users. So the Office of the Public Guardian, it's an executive agency of the Ministry of Justice. It registers lasting powers of attorney, the old enduring powers of attorney. It supervises deputies that are put into place by the Court of Protection. It investigates any allegations of abuse against attorneys or deputies, and it maintains the registers of deputies of lasting powers of attorney and enduring powers of attorney. But I'm going to talk to you about how we digitized it. That's what I'm here to do today. We have this big drive from government digital services in England and Wales, which means that from April, this last April, all new and redesigned digital government services will need to be so good that people prefer to use them in that way. So it's not that they are good, they will need to be so good. And there's quite a strong force and support put into place to make sure that we do that. And I think it aligns a little bit with what Timo was saying. We start at the very, very beginning with discovery with the user's needs. Now, lasting power of attorneys is citizen-facing, so we started with citizens here, but we rapidly moved from discovery of what we need to put into place into an alpha site, it's used with the users that we've used in discovery, and then we move it into a beta site, which goes live as a beta service on our gov.uk website, and then isn't allowed to move into the live service until it fulfills all the requirements that's put into place by a standard, which includes assistive digital, so that everything is as it should be. So the real big focus is, it's quite easy to get the discovery in the alpha, and you can get stuck in the beta phase, but to get it through to the live phase, which means it's absolutely fit for purpose for the users, is quite an achievement for us. Everything that we do through government digital services is on the internet. Everyone can access it. It's all done through open source. The open source is available for anybody that wants it. We have dashboards that are put onto the internet so everyone can see where we're going with it all. So this is part of the dashboard for lasting powers of attorney. And you can see on the right, we started discovery February 2012, rapidly moved to alpha just a couple of months later, went to beta up until July 2013, and then we moved down into the live, and then we continue improving it all the way through. So our approach is very iterative, very fast, and it's a very different way for us to do things. And I think this is part of the transformation, as we sort of have separate technical teams to our digital teams now, and we're learning a lot as we go along with all of this. But the lasting power of attorney was considered quite a simple exemplar to start with, because it's a simple process, but even that can have its challenges. So we're moving from paper-based through to the beta-based, through to this very simple live service. And the website's extremely simple. It's based on open source. It's very easy to change. It can change all the time. We still have people using the paper, and for lasting power of attorney, it's quite a lot of forms that have to get filled in. That seems quite complex with support needed. And we're trying to make it much easier and faster and more efficient by using a digital online application. So we're talking about the drivers. We've really got three drivers here: meeting user needs, digital by default, and reducing cost. And those are the three drivers for everything we do right across the justice system. We're using what's called an agile development. So it's a different way of building our services here to build this core digital service that rapidly gets out into the users, and then it gets continuously improved rapidly to make it better. The digital by default, as I've mentioned before, we don't really have a choice now. We have to redesign our programs so that they are better for the users there, and to be digital so that people prefer to use them digitally, and to reduce the costs. So it's too early to say the cost from the lasting powers of attorney, but we've got some figures from last year. The government digital services, so that's for all the government digital services, has saved 250 million euros by really three approaches: scrutinizing all our digital and IT spend, and we are prevented from taking out contracts with suppliers that don't meet the government digital services approach. We are supported through making sure that we're moving into a new direction here. Transitioning all our websites for all our services onto one site, gov.uk, which actually saves an awful lot of money, and transforming the way we are actually delivering our online services. So it's a very big thing for us in the UK. Another part of the dashboard, part of the transparency. So you can see from here just under 7,000 live applications in the system. But from that slide, we only have, I think it's 12% digital at the moment. So we're about 87% on the paper base. What we're trying to do is to move that round the other way so that we have about 80% digital applications by 2016. But we also measure our user feedback. So on the 30th of September, 90.5% of the people using the digital service were satisfied with it. And we take a daily service of our user feedback on here. So you could see it's been pretty stable at this. It goes up and down the 90 mark. We think that's quite good, but we're not complacent about it all. But this is all transparent. So anybody who wanted to have a look at how we're doing these things will have a look at all the dashboards of all our exemplar services. So some of the successes. We anticipate 300,000 applications a year on this. More people seem to be interested in putting into place lasting power of attorney. We've had very positive feedback, the 90% from the users so far. The lasting power of attorney has been named as a runner-up in the Civil Service Award, so it's getting recognition for this big push for digital services. But a real good benefit here is the reduction in error rates as you move from the paper-based to the digital. So people are supported with the right information as they're filling in the form at the right time, and that's definitely reduced the error rate of people sending in a paper base that can sometimes take quite a while to get sorted. But also 90% of our digital users are paying online instead of putting into place checks. So 3.5 million euros have changed to paying online there. And it's now in live service release, which we're quite proud of. But the challenges. So the Office of the Public Guardian is quite a small agency, but even as a small agency, it had to transform to become a digital agency in order to put this into place. It affected all their systems that they had. Another thing is building so rapidly a very simple open source service. There wasn't the big service wrap, the service support that you'd have if you put into place a very large, a very long an IT procurement of a service. This new approach has a challenge of how to make sure that you're just digitizing the application, but you need to have the support behind it all. And also going first, because everybody's asking for help as well, but they didn't have anyone else to ask there. And another really big thing we found is the staff that you have are very different. The digital skills, the design of solution skills, different people for the people who are working in our technical teams. It seems to be very different, a different approach. We're also really challenged by the fact that we need a wet signature because this is a deed. Now, we might need legislation changes here to get through that. But currently, even though we have a digital system that starts digitally and ends digitally, in the middle they have to print the form out and put a wet signature on it and send it in. And so we know that that's a big challenge that we need to address, but it's a hard challenge there. Because it's a deed, we currently will have to work on that. So overcoming design and implementation problems, how do we do this? So this is what we're doing with all our digital services, including the criminal justice system, in part of the, I'll have one slide on that later. It's using an agile approach, which is open and transparent. We're starting off much closer to the users, but we're empowering the teams. So normally when you're putting into place a service, an IT service, you'd have sort of project management reports that go in monthly. We have daily meetings, we have weekly reports, we have stand-up meetings. It's definitely a new approach and a new skill. But the people in the team have to be empowered to be able to identify risks and do something about it without asking for permission. Because everything moves so fast, it can get changed so fast. So risks get identified very quickly, they get changed, and if that doesn't work, it gets changed again. So it's very different. We're also procuring off new government digital frameworks, which are smaller companies. The contracts are for smaller time. We don't want to be locked into a long IT service that means it doesn't meet any future needs of our users. So really everything is being changed in the way we're doing this digitally. So it's almost a new language for us, this agile delivery. So people start talking about Scrum methodology, building things incrementally, iteratively, small projects delivered quickly, focused on user need. We're testing with the real users, which is really important. So you'll find the UK always is talking about you must test with the real users. If it doesn't meet their needs, they won't use it. Quite simple as that. We use sprints, very short time box cycles. The walls in the Ministry of Justice now are covered with little bits of paper everywhere. It's just changing actually how we work completely with our teams. You don't have to ask the experts, you ask for anybody's opinion because they have a different opinion. So we're moving from looking at customer outcomes. So we're not measuring how long the piece of paper has gone through the process. We're looking at the impact on the customer. So that's the whole purpose for our digital by default approach. But this is the map of what we're really completely doing. This is the whole of digitising the Ministry of Justice. You've got 4 exemplars, a little bit small for me to read there. We've got civil claims as an exemplar, fee payment as an exemplar, prison visits booking as an exemplar, and the Office of the Public Guardian. 3 of those 4 exemplars are live, well, in beta. The Office of the Public Guardian is live. But underneath all of that, we've got the transactions, we've got the implementation services. These boxes, because it's an agile approach, are allowed to move up and down because they will change as the teams change them. And right at the very middle of there is the digital file that Lord Kerr spoke about. In our digital justice system, we need to be able to share this digital file in the middle that goes into everybody's systems. So we are building on that with the vision of going out at the other end by 2016. There's a lot of work that's involved in all of this. It's a little too small. I just wanted to demonstrate that Lasting Powers is just the very first one that's gone live for us, and we've got a lot of work to do. But the challenges for the criminal justice system, the OPG was the Office of Public Guardian was a single agency, but the criminal justice system is much more complex. We have to integrate between many of the different players, and everybody has a different system. So we have to look at interoperability here, and we have to have digital case files. But we also have this big focus on digital evidence here because crime is becoming more digital, but even the evidential base for crime that's not digital is digital. So there's a really big focus about how everyone can access secure digital evidence here. So the teams on our criminal justice efficiency system are looking at building not a digitized system of what we've got now, but they're trying to really break the mold. Teams looking at what can be put into place now that's going to start to meet some of these future needs. And they are doing it in this agile way with stand-up meetings and scrums and sprints and all of that, trying to identify the benefits and trying to put the user first. So not just citizens users, businesses users, but the legal profession and the judges and the courts and everything like that. So there's quite a lot that we're doing there. And if anybody wants any more detail of any of that or any of the source code, we have some links here. I think you'll have access to the PowerPoint. And Kit from the very bottom, she's head of digital for the Office of Public Guardian. If you've got any queries on any of that, she'd be very happy to answer any questions. So, thank you. Okay. Perfect.
Thank you, Christine. Let's move to Giulio Borsari. Giulio is an information technology engineer. He has been working at the Ministry of Justice in the IT department of Italy for many years. He's considered one of the father of the so-known processo telematico, try online. Giulio, the floor is yours.
Grazie. Allora, il protocollo mi obbligherebbe a parlare in italiano, ma io ho deciso di infrangere il protocollo della Presidenza e di parlare in inglese, così di allinearmi. Però mi consentite un minuto di ringraziamenti. Qui vedo in platea delle persone che hanno fondato il processo telematico, oltre che la mia direzione generale, la dottoressa Rolleri, il consigliere Brescia, il collega, ex collega purtroppo, Antonio Baratta, che è venuto qui, anche se adesso lavora per un'altra agenzia. Con un po' di emozione dico che con loro siamo stati alla primissima conferenza di Justice. In realtà non c'era ancora una conferenza di Justice, era una sessione all'interno di una conferenza Justice ad Edimburgo durante la presidenza inglese nel 2005. Poi siamo stati ospiti di Martin Schneider, l'amico austriaco, a Vienna, e poi siamo stati a Loughborough, la bellissima conferenza del 2006. Poi siamo stati ospiti tedeschi. Insomma, abbiamo visto nascere l'e-justice europea e ho avuto il piacere di lavorare con queste bravissime persone per il processo civile telematico italiano, che adesso illustrerò in inglese. Molti amici italiani, magistrati, avvocati, amici europei con cui sediamo ai tavoli e-justice, con cui partecipiamo a progetti europei molto affascinanti ed importanti come i Codex, e vederli tutti insieme mi fa molta impressione, perché forse stiamo uscendo dal nostro territorio nazionale, dalla nostra provincia, e incominciamo a vedere come il sistema nazionale può collegarsi, lo vedremo domattina in realtà, con i sistemi europei, e il processo telematico è già collegato, quindi io vi sto illustrando un sistema che è già collegato con i Codex. E saluto infine i colleghi che con me lavorano al processo telematico, Anna Candellieri, Mauro Di Giacomo, Giuseppe Barrile e tutti gli altri anche di questo ufficio della Corte di Cassazione. Okay, then I turn to English because I like to, no, not like to speak English, but I like to present it in English, as I said. So, just to fill you the context of Italy, because it's not a simple context. It's full of courts, it's full of people, and especially I would like to just some figures: 140 tribunals, 26 courts of appeals, 1 Supreme Court, 465 Justice of Peace offices, and a lot of pending cases, as you probably know, and a lot of new cases every year. So this is our pretty difficult context we have to deal with. But just to give you a glance of PCT. PCT is acronym for Processo Civile Telematico, of course. It's basically the e-government plan of civil justice, and not just civil justice in Italy. And it supplies services to lawyers and assistants. Another figure is 200,000 active lawyers. We have about 250,000 increasing lawyers in Italy. 200,000 are really active. So we looked into our databases and searched for real active people, so at least one proceeding running in civil courts, and this is the number. So a lot of people, a lot of assistants, a lot of judges, like 3,000, and office clerks, which unfortunately are decreasing because there's not so much turnover. What are the key features of this system? It's highest level of security and confidentiality. This also means complexity. So the same medal is good on one side, of course, means complexity on the other, as we will see. We adopted all technological standards, and we have chosen the openness to the market. So everybody on the market can build applications interfacing with our system. Now, what is the architecture? I don't want to go into details at all, but just to give it a glance, we have on the left side our lawyers and practitioners, citizens, public companies, and private companies. Then on the left side, we have judges and clerks using our system, the systems provided by the Ministry of Justice, installed and deployed in district data centers. So we provide applications for judges, application for clerks, and of course the docket file, electronic docket file. So all acts are in PDF with an XML providing structured data, are digitally signed, also have attachments, and they are encrypted. This is the specifications that we give, and of course they need to be transmitted to the court, what we call e-filing, what we all call e-filing, and we use a certified email system, which is an Italian invention called Posta Elettronica Certificata, certified email. So it's basically an email that gives the proof of receipt. So the lawyer has, in return, has an email message signed by the receiving system, so the mailbox of the Ministry of Justice, of the single court, in order to say, okay, I'm sure that has been delivered. So this is the formal proof of the delivery. The magistrates, the judges, use an internal e-filing system, so not the mail system, it's not necessary. They use their application to do it, and it can be also used outside the office, so on the internet, on a secure channel, of course. Then for all other online services, like access to the files, to the information, real-time information, they need to be identified through what we call access points or the Italian portal. And this is for lawyers, for citizens, for everybody, so they can choose systems made by their own bar associations or private companies or our system. And the same feature is that we want two-factor authentication, so a strong type authentication, in order to be real sure that whoever gets in is identified at the maximum level of security. What is the timeline that we have had? We worked since a lot of years, but starting with the first court activated in Milan, Court of Milan in 2006, and we basically finished up because it was on a voluntary basis, meaning that the single court decided together with the Bar Association if they were ready, and then we activated the system. But then at the end of June, we had a new law which made it mandatory for injunction and pleadings in new cases to file only electronically. So from that date, there was no need to activate or not, because every court, every tribunal actually, so first-grade courts, the lawyers need to file only electronically. Then another date, which is in the future, is that it will be mandatory for all pleadings, not only for new cases, starting 31st of December of this year. And at mid of next year, it will also be mandatory for courts of appeals. What are the numbers we're dealing with? From January 2014, of course, we had a jump on July, because after 30th of June, it became mandatory to file injunctions and some other acts. So we received almost 600,000 e-files from about our analysis is to 62,000 distinct external users. So not yet all the users, but some of them. Also because a lawyer can also use a mailbox of his colleague, of her colleague. So it doesn't necessarily mean that he uses its own mailbox. We can accept e-files also from whatever mailbox that we have, of course, in our directory. The important is the digital signature put on the act. And also the judges, to our surprise, basically, have filed almost a million documents. And this is the a little drill down information, because as you see, the judges build a lot of documents, especially also the ones that are not mandatory, like minutes of hearings, decrees and sentences. And this is just from January. We have a lot more if we consider more a longer time frame. Then about communication, which is a big result for us, they have been migrated to the certified mail system in November 2011. Then they have been mandatory since February 2013. So every court needs to send them electronically to a certified mailbox that belongs to the lawyer in only electronically, so via PEC, and it will be mandatory also for criminal cases at the end of this year. And the numbers are pretty big because it's free also. So they send 1 million communications every month, and we calculated on saving of money because, of course, we avoided the bailiffs. And in this case, our estimate is about 40 million euros saved every year. We also have the access to registers and files. We have about 4 million daily accesses also via mobile apps to our systems, and data and files, as already told you, are available real time. And we also have the e-payment of court fees. I don't want to go into details, so in a nutshell, it's a system, okay, I can jump on it because I'm a little late, so just it's a secure system that allows to have a digitally signed single usage e-payment receipt to bring to the court. And this is the number of payments we have, of course, been increasing because of the introduction of the mandatory e-file system. Actually, there are not so many, to tell you the truth. So, but it's not our problem. It's problem of banks and payment systems that are not really ready. So we hope that more banks will come into the system. Just to give you a little glance of our return of investment. We have spent about 30 million euros to do all the system for all the online services I've just illustrated to you in the last 10 years. And we have been saving more than
real-time live access to the files with all these multiple agencies having interoperability to be able to get to it. And I think that's what we're looking for in the UK.
Very interesting question from Martin about the cloud. We are thinking about adopting a cloud, but a private cloud, meaning that, at least in my opinion, it should be private because we don't want anybody to go into it, and we don't want anybody to modify it. But anyway, we still need to understand the costs of having a private cloud and to maintain it very available all the time. So it is a process that we need to start, and we are start thinking about it, but it's not so easy, in my opinion. So because of these so many users we have, and the need to provide a real highly available system. But in my opinion, it should be a private cloud.
Thank you for the questions. Regarding the document management system, I use the term document management system, but in fact, it is, we basically developed it ourselves. It's not a ready-made solution in that sense, but in fact, the courts, the systems, what they actually use, they are like a document management system is only designed for the specific needs of the courts. They have to upload documents, and of course they have to register certain kinds of events like court hearings and so on, but that's the reason why I said document management system, but in fact it is very specifically designed just for the Estonian courts, but it's quite flexible, so if you want to use it, contact me. Regarding the mechanism for waiting cases, what we did was that we gathered, again, a group of judges from all over Estonia, again, like maybe 15 or 20 judges, and we had this list of categories of cases, and based on this list, basically, the judges themselves said that they gave points to different types or categories. And in addition to these categories, we also take into account like maybe other criteria, like let's say in criminal cases, how many the criminals are dealing with, how many episodes they have already, how many episodes of crime they have committed, and so on. So basically, they agreed this system on a very general level. Nobody is looking at a particular case in the office and saying that, well, this is now 10 points or 50 points. Just based on the categorization, as the judges themselves have agreed, as I said, that the labor dispute is, let's say, 10 points and a divorce is 1 point, it's legitimate in that sense that this is how we use it. And then the system, we insert the data into the system, and then the system allocates cases. If the court wants to allocate cases based on the workload, it takes into account these weights. If the court wants to allocate cases based on the number of cases, it doesn't take into account the weights. But it's very general in that sense. And we didn't also, I know that in Germany and I think also in Austria, they have had very complex projects dealing with the weighting of cases. They have used stopwatches and so on to monitor the time. We didn't do that. We let the judges themselves agree. And as to the time, to the limit of these files and then the cloud technologies, in Estonia, I would say that the e-file can be called a cloud in that sense that we store the data in this e-file system, and everybody, like starting from the barristers who use the public e-file and also from the police and the prosecutors and the courts, they use the data which is already in the e-file. So in a way, it is a cloud. But we do also have a limit to upload documents, and if I'm not mistaken, it's at the moment, I think around 50 megabytes. There is no real technological limit in that sense, but it's just like a administrative limit in that sense that we don't want people taking pictures of their documents and uploading pictures. We just want to use sensible formats. So this is the reason. Thank you.
Thank you, Timo. I'm sorry to be forced to close this session, which was, I think, very, very interesting. I thank you very much for attending the session, and please let me applaud again the panelists for their efforts. And it's time for the coffee break. We will reconvene here at 5:15 for those of you who want to attend the cross-border criminal cases, 4:15, sorry. And the other session will be cross-border evidence, the fourth floor. Thank you very much.
Allora possiamo riprendere i lavori della seconda sessione, che è dedicata ai cross-border criminal cases. Alla tavola rotonda partecipano Giovanni Russo della Procura Nazionale Antimafia di Roma, Francesco Lovoi, che è il rappresentante nazionale per l'Italia all'organismo Eurojust, ed Ernst Steigenga, se la pronuncia è esatta, il rappresentante olandese che partecipa al progetto e-Codex. Non voglio togliere tempo alle relazioni, dico soltanto, perché vorrei che su questo si soffermasse la riflessione di questa sezione, che il carattere transnazionale dei crimini richiede da parte di tutti gli addetti al settore della giustizia, in primo luogo, una conoscenza approfondita del fenomeno o dei diversi fenomeni che sono chiamati a fronteggiare. 2, un'elevata capacità professionale e quindi l'attitudine ad una continua formazione professionale. 3, uno sfruttamento di tutte le potenzialità anche tecniche di tipo informatico per realizzare una conoscenza organica dei dati ed organizzarli. 4, una nuova mentalità professionale dei magistrati, ma più in generale di tutti gli addetti. 5, la condivisione in ambito europeo di alcuni principi comuni che devono ispirare l'azione di contrasto al crimine transnazionale. 6 e ultimo, uno spirito di leale collaborazione fra i diversi Stati per fronteggiare queste manifestazioni criminali sempre più pericolose. Ed è quindi in questo ambito che rivestirà particolare interesse sentire l'esperienza dei partecipanti a questa sessione, perché ciascuno di loro nei rispettivi ambiti professionali ha maturato esperienze particolari, ottenendo anche risultati significativi che vale la pena di condividere per progredire ulteriormente. Allora, grazie e passo la parola al dottor Giovanni Russo della Procura Nazionale Antimafia.
Buonasera, vi ringrazio, saluto tutti i presenti. Il mio intervento sarà in italiano. Per i nostri ospiti stranieri ho preparato le slide in inglese. For our foreigner guests, I prepared some slide. Il contesto in cui noi andiamo ad operare è quello che è stato descritto dal consigliere Cassano. Un contesto in cui il crimine non conosce confini e un contesto nel quale ogni Stato si è attrezzato per contrastare questo fenomeno criminale quando abbia le caratteristiche di transnazionalità. Nel nostro ordinamento è stata prevista la individuazione di una definizione di reato transnazionale, i cui estremi sono quelli che vedete riportati alle mie spalle. In relazione a questi casi è prevista una circostanza aggravante, quindi quando ricorrono queste condizioni la pena viene aumentata in maniera anche sensibile rispetto agli aumenti di pena previsti dal nostro codice penale. Qual è il tessuto concreto in cui questa norma si va ad applicare? Ho provato ad estrarre i dati relativi all'ultimo triennio, in realtà è dal 1 gennaio 2012 al 30 settembre 2014, per capire quale è la dimensione nel nostro Paese del reato con caratteristiche di transnazionalità. Nella tabella potete vedere una prima parte delle direzioni distrettuali antimafia con la indicazione del numero dei procedimenti e del numero dei soggetti indagati per reati transnazionali. Questa è la seconda parte dell'elenco delle 26 procure distrettuali. Va precisato che il reato transnazionale può essere ipotizzato, quindi questa particolarità, questa condizione, anche per reati non di competenza delle direzioni distrettuali antimafia. Quindi questo è un elenco più ridotto del reale numero di procedimenti e di soggetti indagati in relazione a un reato transnazionale nell'ultimo triennio nel nostro Paese. Questa tabella vi mostra graficamente gli stessi dati e si vede come ci sono dei picchi particolarmente significativi. Le colonne rosse indicano il numero dei soggetti indagati, quelle verdi il numero dei procedimenti. Non sempre ad un numero contenuto di procedimenti corrisponde un numero ridotto di indagati, ma questo è nella natura del crimine e della tipologia dell'offesa criminale che si indaga. Questo è un po' un riepilogo. Possiamo dire che nell'ultimo triennio sono stati instaurati nel nostro Paese, ripeto, presso le 26 procure distrettuali, 261 procedimenti per reato transnazionale, a carico di 2.501 soggetti. Sono dei numeri enormi, sono dei numeri, come dire, che tacciono una realtà ancora non censibile qui e probabilmente una realtà non ancora percepita fino in fondo da parte delle forze di polizia e delle procure, soprattutto le procure ordinarie, ma sono dei numeri molto rilevanti. Non contento di questa rilevazione, mi sono domandato se fosse possibile nel nostro sistema che non risultasse contestata l'aggravante o l'ipotesi del reato transnazionale e allo stesso modo le procure stessero indagando in relazione a procedimenti che vedessero l'attività delittuosa commessa in parte in Italia e in parte in uno o più altri stati esteri. La tabella che vedete, che vi mostro, segnala dei dati, come dire, positivi dal mio punto di vista, perché tutto sommato sono marginali i casi in cui siano stati iscritti dei procedimenti che teoricamente potrebbero far pensare alla necessità di ipotizzare un reato transnazionale e invece non vedano annotata questa condizione. Soprattutto con riferimento al dato, come dire, all'analisi diacronica nel tempo, si vede come dal 2012 ad oggi si sia registrata una maggiore attenzione da parte delle procure e delle forze dell'ordine nella contestazione di questa aggravante. Infatti, mentre nel 2012 abbiamo 65 casi di processi che vedono commessi reati in Italia e in altri stati stranieri e non vedono contestata l'ipotesi della transnazionalità, questo numero si riduce a soli 16 nel 2013 e a un solo caso nel 2014. Quindi diciamo che l'apparato giudiziario risponde bene alla introduzione di una norma che ritiene verosimilmente confacente alle esigenze di contrasto antimafia che il legislatore e prima ancora la Convenzione ONU di Palermo aveva posto. Questa è la stessa visione, diciamo, degli stessi dati. Che cosa sta cambiando? Se questo è lo scenario, bisogna dire che bisogna attivarsi per fare fronte a questa situazione nuova che il legislatore ha conosciuto, ha formalizzato, ma che forse gli apparati investigativi, di polizia, di contrasto delle procure diciamo, non sono in grado di fronteggiare adeguatamente. Va detto qui, e non solo perché sta entrando in questo momento in aula, che la Direzione Nazionale Antimafia intende formulare un apprezzamento convinto, compiaciuto della collaborazione che la DGSI, la Direzione Generale dei Servizi Informativi, negli ultimi anni sta dando al sistema di contrasto antimafia. La cosa più importante che ci ha colpiti è il fatto di aver condiviso un metodo di lavoro, cioè quello di porsi concretamente di fronte alla necessità di perseguire degli obiettivi con gli strumenti i più avanzati che fosse possibile rinvenire in campo, diciamo, planetario. Faccio una piccola parentesi perché so che è gradita al consigliere Lovoi. La DGSI ha messo a disposizione da tempo e sta rinnovando gli sforzi per assicurare la funzionalità del sistema SID-SIDNA, che è la banca dati, diciamo, evoluta al servizio delle indagini antimafia. Si tratta di una delle banche dati giudiziarie più avanzate del mondo. Non abbiamo tempo in questa sede di analizzarne le funzionalità. Voglio darvi due dati che mostrano quanto è potente e quanto sia significativo il suo ruolo nelle nostre attività. Noi riceviamo settimanalmente richieste da parte delle forze di polizia e di magistratura di tutto il mondo che ci chiedono informazioni contenute nel nostro database o ci chiedono di elaborare le informazioni che loro ci forniscono all'interno del nostro database. È un riconoscimento di una capacità elaborativa, di una capacità analitica che, diciamo, supera le possibilità dei paesi richiedenti. Le dimensioni della banca dati SID-SIDNA. Noi abbiamo provato a compararla con i database più significativi dal punto di vista investigativo che esistono al mondo. Europol è il database che contiene gli atti di polizia delle polizie europee. Prendendo in considerazione il dato dei soggetti inseriti, censiti, i nominativi delle persone che sono censite nel database di Europol, al dicembre 2013 erano circa 70.000 nominativi. La banca dati, il database mondiale più rilevante per le forze di polizia, quello di Interpol, al dicembre 2013 aveva poco più di 150.000 nominativi. La banca dati della Direzione Nazionale Antimafia a dicembre 2013 aveva poco più di 1.450.000 nominativi. È una capacità di acquisizione perché deriva dal sistema che è stato creato, che è un sistema di immissione automatica o semiautomatica delle informazioni investigative, informazioni che vengono vagliate da un magistrato, quindi è una banca dati giudiziaria e non di polizia, e questo ne qualifica il contenuto. È un sistema che viene alimentato quotidianamente dalle attività di indagine che vengono svolte dalle 26 procure distrettuali. Se questi sono i termini, quindi abbiamo un grande strumento interno che viene invidiato ed è apprezzato anche dagli osservatori stranieri. Se è oggettivo l'interesse per il nostro Paese, ma credo che il censimento che ho svolto sia applicabile e replicabile anche con riferimento alle altre nazioni, allora bisogna cominciare a porsi rapidissimamente, per i tempi assegnatimi, porci alcune domande e fare alcune riflessioni. C'è un problema di formazione della prova. Questo sembra esulare un po' dal sistema delle banche dati. Noi abbiamo una prova che è sempre più una prova digitale. Esistono delle linee guida per la formazione di una prova digitale? Non esistono a livello nazionale, meno che mai esistono a livello europeo o sovranazionale. Sono problemi, perché una prova digitale, sull'acquisizione di intercettazioni telefoniche piuttosto che di l'esito di una perquisizione, abbiamo una giurisprudenza sufficientemente consolidata nell'utilizzo di queste prove raccolte in altri ordinamenti e in altri paesi. Sulla prova digitale manca ancora tutto questo. Perciò forse arrivare alla creazione di una sistema di linee guida potrebbe risultare utile. Ma la tecnologia non ha portato una rivoluzione solo nel campo della formazione della prova, ma nel campo stesso della conoscenza. Vi facevo prima il riferimento alla banca dati SID a SID. Noi parliamo di big data, non lo leggiamo soltanto nelle riviste specializzate o nei giornali o nella letteratura scientifica. Big data è quello che sta attorno a noi. La stessa banca dati SID a SID ha assunto le dimensioni di complessità e di popolamento tali da essere considerata big data. E allora dobbiamo mettere a fattor comune gli strumenti per analizzare big data. Dobbiamo passare a big analytics, perché dobbiamo esportare in qualche modo, se il modello è un modello che piace, dei nostri operatori, dei nostri investigatori, che non sono altro che gli operatori della conoscenza, operatori della informazione, che di per sé, in quanto immateriale, non può conoscere confini. Qual è il vantaggio se noi adottiamo questa logica dal punto di vista degli investigatori? Apro una piccolissima parentesi che non vuole suonare minimamente animata da spirito polemico, ma solo per ravvivare un po' e portare il pensiero di un PM in un'aula che è stata, come dire, ha sentito le parole alate di tanti giuristi diciamo, e specialisti della tecnologia che forse non fanno direttamente le indagini. Stamattina ho sentito il commissario della UE alla giustizia fare riferimento alla strategia per la giustizia, anche attraverso il portale e-Justice, l'e-Codex, eccetera, fare riferimento a 3 soggetti fondamentali: i citizens, i businesses e i legal practitioners. E chi fa le indagini dov'è? Nella terza categoria? Io trovo un po' riduttivo. Penso che questa visione, che è corretta dal punto di vista di chi da politico deve gestire la giustizia, è una giustizia che, come dire, si pone non tanto per addetti ai lavori, diciamo, non a chi sta in sala macchine, ma serve ai turisti della nostra nave da crociera, a tutti quelli che in qualche modo hanno a che fare col diritto e che hanno giovamento nel trovare in un unico portale le leggi sul matrimonio della Slovacchia, così come quelle della Svezia, così come quelle del Portogallo, o addirittura si trova sullo stesso portale, magari nella stessa lingua, con uno stesso formato, la possibilità di investire il giudice per una richiesta di volontaria giurisdizione, per una richiesta di un certificato del casellario. Questo è benissimo, come dire, significa il progresso e la civiltà come dire, anche giuridica di una struttura sovranazionale come l'Unione Europea, ma è cosa diversa da quelli che sono le nostre mete. Noi abbiamo bisogno di condividere con i nostri partner di polizia e di controllo giudiziario delle investigazioni delle strategie. Dobbiamo ricostruire insieme gli scenari criminali e per far questo non credo che ci basti un portale dove non possono essere esposti questi dati. Sir Francis Bacon diceva: scientia est potentia, la conoscenza è il potere. Se noi vogliamo contrastare il potere criminale, dobbiamo darci da fare e non ritenerci appagati della conoscenza singola, individuale. È un po' l'insegnamento di Giovanni Falcone. Quando lui ruppe le pareti che dividevano le stanze della procura di Palermo o dell'ufficio istruzione di Palermo, dicendo che dovevano dialogare i colleghi, dovevano essere condivise le informazioni nei fascicoli. Quando la costituzione del network direzioni distrettuali antimafia e direzioni nazionali antimafia pone come postulato della sua stessa esistenza quella della condivisione delle informazioni, perché non esportare questo sistema in maniera da travolgere quelle che sono, dal punto di vista tecnologico, quelle che sono le pur legittime differenze tra gli ordinamenti giudiziari gli ordinamenti giuridici dei vari paesi. Siamo in un mondo, e mi avvio alla conclusione, in cui diciamo, alle volte io avverto una difficoltà. Io leggevo che tempo fa in un libro di storia antica che le popolazioni amazzoniche contano fino a 4, 1, 2, 3, 4, sanno computare fino a 4, dopo il 4 c'è il molto. Loro non distinguono più, noi siamo molto più evoluti e abbiamo questa numerazione che abbiamo appreso a essere infinita. Alle volte noi nell'utilizzo degli strumenti che la tecnologia, ma anche che la logica ci mette a disposizione, ho l'impressione che facciamo la parte di quelle popolazioni amazzoniche. Ci fermiamo prima di aver capito che in realtà le potenzialità sono infinite. Non esiste più la Inquisizione. La nuova Inquisizione è elettronica. Non bisogna più fare la tortura, per fortuna. Non bisogna fare neanche le domande. Spesso si hanno le risposte attraverso i sistemi automatici senza aver fatto le domande. Quando Alan Turing, col suo test, lui provò a simulare che una macchina rispondesse agli input, agli impulsi, alle domande come se si trattasse di un uomo, e chi faceva le domande non sapeva se di là c'era un uomo o c'era una macchina. Alan Turing ha dato vita a quella che è la logica della era attuale, del sistema del M2M, machine to machine. E non è questo che noi dobbiamo chiedere ai nostri sistemi, in grado di condividere in maniera automatizzata informazioni senza che l'uomo, quell'uomo di cui abbiamo diffidenza, perché è l'uomo a noi ignoto, a noi straniero, a noi estraneo e che può captare per chissà quali fini loschi la nostra informazione giuridicamente sensibile. Io non voglio arrivare alla esasperazione di Bowman, che proprio qualche mese fa a Roma, in una sua partecipazione a una conferenza, raccontò quell'aneddoto così divertente secondo il quale nel futuro nei nostri opifici industriali ci saranno solo 2 esseri viventi, la presenza di solo 2 esseri viventi. Uno sarà un uomo e l'altro sarà un cane. L'uomo avrà il solo compito di dar da mangiare al cane e il cane avrà il compito di impedire all'uomo di toccare il computer che farà tutto da solo. Non bisogna arrivare a questo. La mediazione, diciamo, del giurista in particolare è ancora importante e preziosa, ma se potessimo sfruttare certi automatismi per vincere degli ostacoli che noi stessi frapponiamo al nostro percorso, forse ce ne avvantaggeremmo. Concludo davvero. Quali sono un paio di proposte concrete, e so che il consigliere Lovoi ha già lavorato nella stessa direzione in Eurojust e diciamo per poco non siamo ancora arrivati alla meta, ma gli intenti sono assolutamente comuni. Bisogna individuare innanzitutto un linguaggio comune per condividere le informazioni. Nella prossima slide darò conto di uno dei progetti che ha avuto 4 edizioni, organizzato da Eurojust e dalla Commissione Europea, il progetto IPOC, che mirava proprio a questo, in ambito europeo, a individuare i linguaggi comuni per potersi trasferire i dati di registro penale. Non si arrivava ancora a voler trasferire i contenuti delle indagini, ma almeno a metterci d'accordo su che cosa significa indagato, che cosa significa sospettato, che cosa significa imputato. E, apro parentesi, sono stato 2 settimane fa ad un convegno internazionale della ETSI. L'ETSI è un organismo europeo di standardizzazione dei protocolli telefonici, soprattutto. Mi interessava per la questione delle intercettazioni telefoniche. Lì si è discusso per una buona giornata su che cosa fosse il target, che cosa è l'obiettivo, perché per alcuni paesi il target è la persona della quale si intercettano le comunicazioni, per altri paesi è il numero di telefono, per altri paesi è la SIM, per altri paesi è l'IMSI, per altri paesi è il nodo telefonico dove si attesta la chiamata proveniente dal terminale mobile della persona. Quindi quando dobbiamo fare una rogatoria, dobbiamo condividere le informazioni, se non sappiamo che il target identifica lo stesso oggetto, abbiamo difficoltà anche per questo. Quindi identità di protocollo linguistico in senso tecnologico. Secondo, identificazioni delle piattaforme. Quello che auspicavamo che Eurojust imponesse a tutti, delle piattaforme in grado di colloquiare, di far colloquiare le nostre basi dati in maniera automatica, senza filtri, con l'ovvia garanzia della protezione dei dati sottoposti ancora a segreto istruttore e segreto di indagine, ma senza mediazioni di sorta. Se combattiamo insieme il crimine, insieme dobbiamo sceglierne i mezzi e condividere le strategie. Molto rapidamente, di IPOC vi ho accennato un attimo fa, il Ministero della Giustizia italiano è all'avanguardia anche per un'altra stimolante iniziativa, quella di dotare gli uffici giudiziari per la questione delle videoconferenze, ma anche gli uffici di procura delle direzioni distrettuali antimafie. È in corso un progetto di iniziativa di sistemi di videoconferenza, in maniera da facilitare lo scambio di informazioni, di creare dei veri e propri team virtuali di lavoro comune e soprattutto di consentire la valutazione, l'apprezzamento anche dei sistemi, degli aspetti comunicativi, non soltanto verbali. Bisogna, questo puzzle che vedete ancora scomposto alle mie spalle, bisogna darci forza e chiedere a Eurojust e agli altri players dello scenario europeo di aiutare a avvicinare questi 4 omini, questi 8 omini, affinché possiamo avere un tavolo comune in cui tutti i pezzi si sono incontrati tra di loro. Grazie.
Giovanni Russo si interroga sulla possibilità di una nuova epistemologia investigativa e giudiziaria, e a questo interrogativo mi sembra possa rispondere egregiamente il consigliere Lovoi, quale membro nazionale italiano di Eurojust.
Grazie, buonasera a tutti. Non so se sarò in grado di rispondere in particolare a questo quesito. Di sicuro è un tema su cui si è lavorato in passato e si continua a lavorare, però vedete, di solito parlare dopo Giovanni Russo mi viene particolarmente difficile, perché siccome lui è molto più bravo di me, finisco col fare, come dire, cattiva figura. E questa, tuttavia, è una delle occasioni in cui mi fa piacere parlare dopo Giovanni Russo, perché mi ha dato, per usare una terminologia sportiva, una serie di assist che io non posso naturalmente sfruttare tutti per ovvie ragioni di tempo, ma su cui spero di poter dire qualche cosa di comune interesse e nel comune interesse. Cosa fa Eurojust? Eurojust è in qualche misura la proiezione europea della Direzione Nazionale Antimafia Italiana. L'idea di base è quella: una unità di coordinamento delle indagini, in questo caso delle indagini transnazionali e delle indagini riguardanti la criminalità organizzata grave e comunque una lunga lista di reati considerati gravi da tutti i paesi dell'Unione Europea, allo scopo appunto della lotta comune alla criminalità organizzata attraverso lo scambio delle informazioni e attraverso il coordinamento delle indagini nei diversi paesi. E allora la prima cosa necessaria per il coordinamento è lo scambio delle informazioni. Se le informazioni non vengono scambiate, non c'è possibilità di coordinare nulla, perché nessuno sarà mai in grado di dire al paese B: guarda che nel paese A c'è qualche cosa che ti riguarda. Se il paese A non dà le informazioni all'organismo sovranazionale, queste informazioni rimarranno nel paese A e non transiteranno nel paese B, nel paese C e così via. Probabilmente si farà lo stesso un bel procedimento penale, si condanneranno alcuni imputati, però si perderà la visione complessiva del fenomeno e il fenomeno della criminalità organizzata transnazionale ormai si è allargato ad una enorme serie di reati. Soltanto nel 2013 Eurojust ha registrato, come noi definiamo l'apertura di nuovi procedimenti, di nuovi casi, ha registrato circa 1500 nuovi casi. Non tutti questi erano casi complessi che richiedevano particolari operazioni di coordinamento, magari si trattava di semplice facilitazione di procedure di assistenza giudiziaria internazionale, cosa per la quale pure siamo competenti, ma buona parte di questi casi riguardavano i fenomeni criminali più svariati, dalla criminalità organizzata di tipo classico ai mandati di arresto europei da eseguire in contemporanea in più paesi dell'Unione Europea, alle grandi frodi anche e soprattutto contro gli interessi finanziari dell'Unione Europea. Sta diventando un fenomeno drammaticamente in crescita, quello delle frodi attraverso non solo le famose frodi carosello, ma anche le frodi che sfruttano i meccanismi delle frodi carosello e che si avvalgono delle cosiddette compagnie o società missing trader. Anche questo è un fenomeno in enorme crescita ed è un fenomeno transnazionale per natura. I reati informatici, i traffici di esseri umani, ovviamente i traffici di droga, la pedopornografia. Ecco, sono tutti casi e sono tutti fenomeni nei quali la cooperazione giudiziaria internazionale, non solo la cooperazione di polizia, ma la cooperazione giudiziaria internazionale, quantomeno a livello di pubblici ministeri, è indispensabile per un efficace contrasto del fenomeno. Perché dico questo? Non basta la cooperazione di polizia, è importante ma non basta. L'indagine di polizia non viene fatta per il gusto di impiegare risorse umane e materiali. L'indagine di polizia viene fatta con l'obiettivo della proiezione giudiziaria, con l'obiettivo di attivare l'iniziativa di un procuratore, di un pubblico ministero e con la prospettiva di portare i responsabili di determinati reati davanti ad un giudice. Ecco perché è necessario che la cooperazione si svolga soprattutto in cooperazione con le forze di polizia, ma soprattutto in sede giudiziaria, perché nella sede giudiziaria, quando noi consideriamo come giudiziario anche il livello dei pubblici ministeri, che è possibile valutare cosa merita di essere sviluppato. Ed è per questo motivo che la cosiddetta nuova decisione Eurojust, quella del 2008-2009, non da tutti i paesi implementata o trasposta nei rispettivi ordinamenti, prevedeva l'obbligo per ciascuna autorità giudiziaria di ciascun paese di informare il membro nazionale di Eurojust del rispettivo paese, in tutti i casi in cui venisse svolta un'attività di indagine su quella lunga lista di reati che ho indicato prima. Questo obbligo di informativa non è da tutti rispettato e magari forse devo dire che non è da tutti conosciuto, talvolta. Mi dispiace dirlo, ma talvolta è così. E però l'obbligo di informativa prevedeva una risposta, perché l'informativa fine a se stessa sarebbe inutile. Non ci serve riempirci di dati se poi su questi dati non lavoriamo. E tutto questo sarà in un modo o nell'altro riportato anche nel nuovo regolamento che è in corso di esame da parte degli organismi legislativi europei, che riguarda appunto il rafforzamento di Eurojust. Il concetto è: tu fornisci ad Eurojust il dato, Eurojust lo elabora ed eventualmente lo incrocia con gli altri dati a sua disposizione e ti fornisce il feedback su ciò che è stato trovato nelle sue banche dati, attivando quindi il meccanismo di coordinamento delle indagini tra un paese e gli altri paesi, come operazione basilare, come operazione di partenza. Tutto il resto dei modi e delle forme del coordinamento viene dopo, ma intanto questo va fatto. E allora cosa ci vuole per fare questo? Ci vuole non la macchina sorvegliata dal cane a cui faceva riferimento Giovanni Russo, ma ci vuole innanzitutto una macchina i cui risultati di attività vengano esaminati poi dagli analisti, come avviene alla Direzione Nazionale Antimafia. Ecco, ad Eurojust abbiamo fatto questo percorso, si è fatto nel corso dei 10 anni della sua vita, dei 12 anni della sua vita questo percorso, però ancora ci manca un po', ci manca qualcosa. Noi utilizziamo, per riallacciarci ai temi informatici di questo seminario, di questa conferenza, e mi rendo conto che devo andare a stringere, noi utilizziamo un sistema di gestione dei dati che si chiama Case Management System, che segue il caso che noi registriamo, il procedimento che noi registriamo durante tutto l'arco della sua vita e che ha una serie di funzionalità particolari utili, che consente anche l'incrocio dei dati, che consente lo scambio dei dati tra i rispettivi desk, come noi li chiamiamo, di Eurojust, che consente in qualche misura anche l'analisi incrociata di questi dati, che però non consente ancora il caricamento automatico dei documenti ai fini di quell'incrocio automatico a cui Giovanni Russo faceva riferimento come già esistente o come imminente nel sistema in funzione alla Direzione Nazionale Antimafia italiana. Ben inteso, tutto questo avviene col pieno rispetto della protezione dei dati personali, anzi è proprio ai fini del rispetto della protezione dei dati personali che la prima decisione Eurojust, così come la seconda, così come il futuro regolamento, prevedono che non possono essere gestiti attraverso sistemi informatici i dati ricevuti da Eurojust se non all'interno del Case Management System. Attraverso questo sistema, per esempio, è stato possibile al desk italiano di Eurojust, sempre per rimanere legati agli aspetti informatici di questa conferenza, realizzare quella che poi è divenuta una sorta di good practice, e cioè la digitalizzazione di tutti i procedimenti, di tutti i file che noi abbiamo aperti, e si tratta di svariate centinaia, cosa che ci consente di operare in un ambiente sicuro, tecnologicamente sicuro, cosa che ci consente di proteggere i dati personali, cosa che ci consente di lavorare anche da postazione remota, non necessariamente dall'interno dell'ufficio di Eurojust. Quali potranno essere? Alcuni altri desk si stanno avviando verso il cosiddetto paperless office. È anche questa una prospettiva apprezzabile, utile. Ma cosa ci può servire realmente per poter realizzare quei compiti di coordinamento e di lotta comune? E qui non so se le restrizioni finanziarie nelle quali tutti ci troviamo, inclusa l'Unione Europea, inclusa Eurojust e tutte le agenzie dell'Unione Europea, ci comporterà qualche difficoltà e molto probabilmente qualche ritardo. Ecco, ci serve innanzitutto un collegamento effettivo e continuo con gli Stati membri, che si avvalga di quelli Eurojust National Coordination System, che non in tutti i paesi è stato ancora realizzato e che comunque dovrà in qualche modo essere realizzato, perché stava già nella decisione, quella del 2008-2009. Istituzione non solo dal punto di vista delle risorse umane, ma anche dal punto di vista delle risorse materiali. Questi collegamenti informatici dovranno essere realizzati. Ultimo punto. Eurojust contribuisce già al portale e-Justice, contribuisce in maniera ancora limitata, sol perché la sede del segretariato della rete giudiziaria europea, della European Judicial Network, è presso Eurojust. E mi ha fatto piacere apprendere recentemente che la rete giudiziaria europea, il sito della rete giudiziaria europea, che io personalmente considero uno dei migliori siti sulla materia della cooperazione giudiziaria penale in Europa, entrerà a far parte del portale e-Justice. Tutto il resto dovrà essere discusso e la partecipazione più piena di Eurojust dovrà essere discussa. Io mi auguro personalmente che venga discussa, farò in modo che venga discussa, tenendo conto delle specificità di Eurojust, tenendo conto dell'aspetto giudiziario delle informazioni che Eurojust tratta e tenendo conto della necessità di condividere le informazioni in possesso delle autorità giudiziarie. Io non credo che sia necessario nel 2014, come invece siamo costretti a fare, dover ricorrere ad una commissione rogatoria internazionale per ottenere un certificato penale, un certificato delle condanne da un altro paese, salvo quei casi in cui, e il membro nazionale italiano di Eurojust ha questa fortuna, quei casi in cui può essere acquisito direttamente tramite Eurojust, sono casi rarissimi, e questo però dà l'esempio di come una maggiore attenzione su questi punti basilari, semplici, non a costo zero, ma necessari per un reale sviluppo delle attività di contrasto alla criminalità organizzata, possano e a mio avviso debbano essere effettuate e portate avanti. Grazie.
Grazie al consigliere Lovoi per la sua lucida analisi e anche per le due sollecitazioni concrete che ribadisco per la prosecuzione dei futuri lavori. Da un lato la possibilità di una partecipazione di tipo sistematico di Eurojust al portale della giustizia europea, dall'altro la possibilità di creare una sorta di banca dati europea relativa a tutte le condanne diventate definitive nei singoli paesi come strumento per superare i limiti dei nostri confini nazionali. Sono due sollecitazioni concrete nell'ambito di un'analisi ben più ampia che possono essere in futuro tenute presenti. E ora passiamo la parola ad Ernst Steigenga, che partecipa come rappresentante olandese al progetto e-Codex, che abbiamo già avuto il piacere di ascoltare in molte occasioni, tra cui da ultimo a Vienna. A lui la parola, grazie.
Thank you very much. Good afternoon, ladies and gentlemen. I'll try to be as short as possible, and also I will try to adapt my presentation a little bit to what has been said before by Mr. Russo and Mr. Lovoy, because my presentation is not dealing with the investigation and the prosecution of criminals. Now it deals with the resocialization of criminals, so that's a slightly different part. So let me introduce first what we have been doing in e-Codex concerning criminal law. And then I will guide you through this slide, and the other slides I will go through very fast, because these are the ones dealing with the resocialization. But let me tell you, I was very inspired by the words of Mr. Russo, and I was very inspired by the words of Mr. Lovoy as well, that from the early beginning of e-Codex, we have been working quite close with the people at the Eurojust, and we know very well the results of the EPOC projects. Especially the EPOC 4 project, in which we saw a lot of proof of concept where the national solutions of the public prosecutors' offices within the member states were really directly connected. And learning from that position, we have worked in e-Codex in the same kind of way. So we just leave intact everything that's already been settled inside the national solutions for the member states. And what we put on top is just an interoperability layer. So what we do, we make one system in one member state have something valuable, substantial to communicate to a system in another member state. And of course it means that what we really start to exchange needs to be adapted to be understood correctly and exactly the same from one country in the other country. So for this reason, the Euregio mutual legal assistance use case within e-Codex is very valuable to tell about. Euregio is a cooperation between the public prosecutors' offices in Belgium, the Netherlands, and North Rhine-Westphalia, Germany. And I must explain a little bit that the smallest part in the Netherlands, or the tiniest part in the Netherlands, is only 5 kilometers width. So you will see that it only takes 5 kilometers for anyone to travel from Germany through Dutch territory into Belgium. Just imagine what it means for a lot of criminals. It's really easy to get yourself going in all these, easy to go, easy to ride roads, and you can do whatever you want, and it's really hard for public prosecutors, for investigators to start fight these criminals. Early March this year, we have had a ministerial conference between the three countries, and there we were able to show a proof of concept in which a German public prosecutor could directly put into the Dutch system a request for legal assistance. So it meant that from a German office directly sent into the Dutch national solution was sent a request for legal assistance in which an operator was urged to start giving attention to this to this request for legal assistance and able to follow up. Well, this will be in another proof of concept or another pilot phase starting again from early January on, in which it go completely live. So what we see here, I really would like to address Mr. Russo that it's already there, and it's already there because of e-Codex, and e-Codex is just one of the projects that really makes e-justice gone live in Europe. But also very important to state, it's not only the cooperation between the Euregio countries, it's also a first step up towards the implementation of the European Investigation Order. That's why we were very pleased that, for example, Spain, France, and Austria as well have shown a lot of interest in joining the cooperation started with these three countries. But then another step, once we were able to find these criminals and to get them sentenced, there's a lot of different penalties that we can try to inflict on them. Some of which are financial penalties, of which freezing and confiscation are very important measures to at least take out of the hands of the criminals what they've been looking for. So there we see some good cooperations, not only within the European member states, but also good cooperation for example, Turkey. Well, of course, the speeding tickets are always very popular. And then you can see as well, there is also a criminal a pilot going on in secure exchange of criminal data. The exchange of criminal data can be of any kind, but at least we know with e-codex there's something safe, reliable, fast to start exchanging information between systems, national solutions within the member states, leaving these national solutions untouched. In the words or in the presentation of Mr. Lovoy already, the European arrest warrant came alive. Also, the European arrest warrant is going to be supported through the e-codex gateways. And then one that is different from all the other use cases in the field of criminal law in e-codex is the mutual recognition of judgments in criminal cases. It's a framework decision number 909. It's dated back to 2008, and it tells that it's the mutual recognition of judgment. So somebody gets convicted in one country, he asks for a transfer to another country, and you will see if either the judgment is completely recognized or a little bit adapted to national standards, and then somebody can be transferred to the country that he was born or he is living in. I will go this through very fast. It's through cartoons, so it's easy to comprehend, I hope. And I will tell a little story around it. So here you see, this is a Dutch guy. His name is Victor Visser, and he's in some kind of trouble, financial trouble. He's a father of one son. He's swallowing drugs somewhere in South America. What you see that someone is telling the Belgian police that he's gonna be that's gonna be someone with drugs on his body, and when Mr. Visser arrives in Brussels airport, he's being collected and he's being searched for, and then he's being brought to court. He's being sentenced, and here he is in a Belgian cell, thinking about his mother, thinking about his wife and his son, and as you can see, he's writing a rogation. So what you can see here is that somebody that's convicted can ask for a transfer to another country, but it can also be the member state itself that's asked for a transfer into the original country of the convicted one. So this rogation is still being done on paper, but this is also something that we could, at least that we could try to make digital as well. Because more and more you can see these digital instruments getting into prisons as well. For example, within the Belgian prisons, they have introduced the idea of prison cloud, in which prisoners can have digital access to, for example, e-learning, their penalties inside, and all kind of living rules. But they could also be, of course, a service to file a rogation under the framework decision 909. And this can be dealt or pushed through via the e-codex gateway into the country that it belongs to. Well, the moment such a rogation is being asked for, or somebody has asked for such a transfer, it's being judged, of course, by the country that someone is being sent to. So you need to have a public prosecutor, you need to have a judge that really starts considering the recognition and how the sentence needs to be, or the verdict needs to be adapted to the rules of the member states. Well, as you can see, the e-recognition of the verdicts has been done. That's all being done through the e-Codex gateway again. And there you can see Mr. Visser is finally a little bit happier than he was before. So he's going to be transferred from Belgium into the Netherlands. And finally, you can see he's still locked in, but it's closer to home. So at least there's some room for a smile. Okay, so it's kind of a funny story, but of course it's very sad. And that's why this is a little bit different again from the stories of Mr. Lavoie and Mr. Russo, because it's not about fighting criminals, but it's fighting criminals. It's more about resocialization. It's about probation, which of course is very important as well. Once you have somebody convicted, you really want to take him off the path of criminality. Well, e-Codex is not the only one dealing with this framework decision. There's also the iStep and the Steps 2 project, in which you can see where there's no, where it's not technological, that's the topic of interest, but it's more like what kind of information is needed by prison managers, by prison directors, and by probation officers. We foresee to go live in e-Codex, firstly with Belgium and the Netherlands, somewhere late first quarter of 2015. We think it's possible to go rather fast because the basic infrastructure is there already, and that's also, I would say, a prerogative for e-Codex. Once a country is connected for one kind of procedure to e-Codex, it's really easy to follow up with consecutive procedures. And as you might know better than I do, there's really some procedures, cross-border legal procedures that deserve to go live in the interaction between the different member states. So a little bit about the implementation. As you can see, not all countries, not all member states have yet implemented. There are some specific arrangements, for example, if all criminal activities are treated the same under this framework decision. So some countries might say that specific criminal activities cannot be part under this framework decision. So if you have convicted for some kind of criminal activity, that a country says, well, no, if you have done something like this, then you are not allowed to make use of this framework decision. Well, of course, as always in a project, if you start using or start to support a procedure, you must find a criteria and you must find something to make it acceptable that you start using it. So it fits, the framework decision fits into the pilot of the criminal law. There's some data to be exchanged, not only the certificate that goes with the procedure, but there's also judgments that need to be transferred. There's also, of course, the way the recognition has been done. And of course, because people are actually being transferred from one country to the other one, you need a plan how you are gonna prolong with this transfer plan. And I think in this transfer plan, and that's what's going to come out of one of the other projects, the Steps 2 project, the transfer plan takes a lot of knowledge about data protection. Because if you're going to transfer a person from one country to another one, you need to know a lot about the person. Not only of what he is convicted, but also if he is treated for some kind of illness, if he's contagious, if he's... so there's a lot of medical information that you need, but how do we deal with this medical information? So it's not only about technology, it's not only about criminal activities, it's also about the human person himself that you should know about. For the moment, it's very interesting to know, and I think that's one of the benefits of e-Codex as well, that we make it visible how likewise, or how the same procedures or the same cross-border legal procedures are being taken up in these different countries. So we have seen for this framework decision, some countries have developed a central authority to deal with this procedure. In some other countries, it's completely decentralized. So if you start digitally supporting such procedures, you encounter some issues that you really need to overcome. And it's not only that the difference between the central authority and the decentralized approach, it's also that it's not only a central authority dealing with this procedure, but there's also the public prosecutors, the judges, and of course the prison institutions themselves. And you all need to onboard these people. So I have no data yet about the number of procedures being performed already on the EU, but in the Netherlands I can say that at least or over 500 cases per year where people either want to leave the Netherlands or want to come to the prisons in the Netherlands under this framework decision. I think it's time, isn't it? So, okay. I have it a little bit short, but tomorrow morning is going to be a whole session about the codex, and you can ask a lot of questions to my colleagues about how it's organized, how it's dealing, how it's going, and how well we are doing. For now, thank you for your attention.
Grazie anche per quest'ultimo intervento, ho particolarmente apprezzato il richiamo forte alla centralità della dignità della persona che è sotteso alle riflessioni di questi lavori. Vorrei sapere ora se ci sono domande, richieste di chiarimento, di intervento da parte di alcuno dei partecipanti. Prego, se per cortesia ci può dire il suo nome.
Thank you very much. My name is Dick Heijmans. I work for the European Commission. First of all, I would like to thank all the presenters for their brilliant presentations. I just wanted to put the record straight a little bit compared to what Mr. Russo was saying about the Commission's activities. Now, Commissioner Reichertz is not here anymore to defend herself, of course, against the points that Mr. Russo made. But let me assure you, can you hear me? Should I speak up? Okay. I just wanted to assure you that obviously the points that the Commissioner raised in her opening speech do not represent a complete picture of the activities of the European Commission in terms of criminal justice. Let me be very clear about that. I'll give you 3 examples. The first one was already mentioned by Mr. Lovoy, the inclusion of the website of the EGN in criminal matters into the e-justice portal is one example. The second example that I would mention is the European Criminal Record Information System. Now, Madam Chairman, you referred to the need to have a central database, but in fact, there is already a system for exchanging records, criminal records, between the different member states. And this is a project which is supported as well by the European Commission. And finally, of course, just last year, the European Commission came out with proposals to improve the functioning of both Europol and Eurojust and the exchange of information between them. So I hope you won't judge the book on the cover only. Thank you very much.
No, solo rassicurarlo nel senso che era uno stimolo a fare ancora meglio tutto insieme.
Sono altre richieste di intervento? O possiamo considerare chiusi i lavori? Se non ci sono altre richieste di intervento, io sento il bisogno, sia personalmente sia a nome di tutti i partecipanti, di ringraziare le interpreti che da questa mattina hanno lavorato indefessamente, hanno assicurato la migliore riuscita dei lavori. Abbiamo molto apprezzato il loro lavoro, ora auguriamo loro di riposarsi fino a domattina, non molto. E è pronta, grazie alla disponibilità dei funzionari della Corte di Cassazione, l'inizio della visita al nostro palazzo, sperando che interessi. Prego la parola all'ingegner Borsari, ottimo organizzatore, per i chiarimenti ulteriori.
Okay, let me talk in English because I believe that the majority of the people interested in visiting the monumental part of the court will be in English. So please welcome to my colleague who will guide you to this visit. Just to remind you that for whom is not interested to the visit, please be sharp in front of the court in Piazza Cavour, so not on the back where you got in, because at 7:15 the buses will start going, okay? So not all the buses at 7:15, but from 7:15 to 7:30 buses need to leave, otherwise we will be late at the dinner, especially for those who don't take the bus and should wait too much there. Okay, please come here to start the visit. The visit will start exactly here, so the explanation will be for this room, which is very, very interesting, and then she will lead you outside in a nice courtyard with a big monument where we take the picture. And so I just ask you again to be outside with their help, that they will show you where to go for 7:15 in order to go together to the restaurant.